Pledge of Allegiance by Senator Garcia.
Let us pray. Almighty God, we give you thanks for our commissioners. We give you thanks for their staff members. We ask your blessing upon our mayor. Grant them health and strength, knowledge, wisdom, and understanding. Bless them in their going and their coming. Make us as a people ever grateful, not complaining for everything, but thankful for the things that you've blessed us with. We ask that you take from us the temptation to indulge in greed. Help us to work together towards the building up of the common life. Go before us, therefore, O Lord, in this and all our doings with thy most gracious favor, and further us with thy continual help, that with all our works begun, continued, and ended in you, we may glorify your holy name, and finally, by your mercy, obtain everlasting life. Through Christ our Lord. Amen.
Please honor the flag of hope and freedom. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
You may be seated. All right, Madam Attorney, can we move into reasonable opportunity for the public to be heard?
Yes, Mr. Chair.
All right, reasonable opportunity for the public to be heard is now open. When I call your name, please state the item you're speaking on, your name, address, and you will have 2 minutes to speak. Sergi Kelly, Nicholas Rodriguez. Sergi Kelly and Nicholas Rodriguez. Please come up to the podium, to the well. Sergi Kelly? No? Going once, going twice. Nicholas Rodriguez? Going once, going twice. All right. Reasonable opportunity for the public to be heard is now closed. Sergi Kelly, Nicholas Rodriguez? No? All right. Reasonable opportunity is now closed. Madam Attorney, can we set the agenda at this time?
Mr. Chair, may I please have a couple minutes just to finalize? I'm still getting requests.
Yes. Ish, yes. On that note, colleagues, I think, and I know that this may fall on deaf ears, but it is helpful when we submit our request to the attorney's office with ample time, not last minute. Motions, deferral requests, pulled items, bifurcations. We understand that not everything is perfect, but in those cases where it is possible, it is appreciated that we do that ahead of time.
Thank you, Mr. Chair. I think I'm ready now.
All right, Madam Attorney, go ahead.
We do have a few changes. Item 2B1, Commissioner Bastien is requesting deferral to no date certain.
Which is that?
2B1. I also have some requests to bifurcate first reading items. At the appropriate time, it would be to bifurcate 4B and 4C by Commissioner Regalado. I have some requests to bifurcate public hearing items. They are as follows: 5B, Senator Garcia; 5M, Commissioner Milian Orbis and Mr. Chairman Rodriguez; 5O, Commissioner Milian Orbis and Chairman Rodriguez; 5P, Chairman Rodriguez, Commissioner Milian Orbis, and Commissioner Regalado; and 5S, Senator Garcia. I have requests to bifurcate ordinances for second reading at the appropriate time. 7A, Commissioner Bermudez and Commissioner Regalado. 7B, Commissioner Milian Orbis. And 7C, Commissioner Bermudez and Bastien. Also, item 8A1 and its supplement, Commissioner Bermudez and Commissioner Milian Orbis, add this item to the pull list. 8F1 and its supplement, Commissioner Regalado adds this item to the pull list. Items 8G2 and 8G3, Senator Garcia is adding these items to the pull list. 8K1, Commissioner Milian Orbis adds this item to the pull list. 8N4, Commissioner Bermudez adds the item to the pull list. 8N6, 8P1, and 8P7, Commissioner Milian Orbis is pulling these items. 8P8, Senator Garcia adds this item to the pull list. 8P9, Commissioner Milian Orbis adds this item to the pull list. 11A5, Commissioner Bastien adds this item to the pull list. Mr. Chair, on 11A6 and its supplement, Senator Garcia is requesting deferral of this item to no date certain, but I do have a request to pull the item by Commissioners Milian Orbis, Regalado, and Bermudez. The board would need to decide how it wishes to proceed. Do we proceed with the
with
deferral,
it?
or?
I'm happy to withdraw it and proceed with the deferral.
Okay, and it was who else? It was Regalado and who else?
Milian Orbis and Bermudez.
Are the two of you good with drawing your pull since it's going to be deferred with the agenda? Yeah?
Yeah, the
Okay.
senator's going to defer it. Yeah, no problem.
Perfect, I figured. All right.
And thank you. So with the setting of the agenda, the item will be deferred to no date certain. 11A7, Commissioner Bermudez is adding this item to the pull list. Oh, in addition, item 8 and 6, Commissioner Cohen-Higgins is adding her name to the pull list. We also have the following requests for co-sponsorship. 4A, Senator Garcia. 7C, Steinberg. 7E, Senator Garcia. 8P6, Senator Garcia is assuming sponsorship of this item. 8P11, Senator Garcia, co-sponsor. 9A1, Steinberg, co-sponsor. 9A2, Senator Garcia is assuming sponsorship. 11A4, Senator Garcia, co-sponsor. 11A5, Commissioner Bermudez, co-sponsor. And 11A7, Senator Garcia, co-sponsor. The items to be considered at today's meeting will be those listed in the printed final agenda with the additions, deferrals, withdrawals, and scrivener's errors noted in the chairman's memorandum, and the items I just mentioned. The commission will approve all of these items by a single vote setting the agenda, except ordinances for first reading, public hearings, ordinances set for second reading, items 8A2, 8A3, 8A4, 8A5, 8A6, and 8P6, which are your commercial service airport contracts that must be voted on separately and have not been pulled, and the following pull list items: 8A1 and its supplement, 8F1 and its supplement, 8G2, 8G3, 8K1, 8N4, 8N6, 8P1, 8P7, 8P8, 8P9, 11A5, 11A6 and its supplement will be deferred to no date certain with the setting of the agenda, 11A7, 14A1, and 14A2. A motion to set the agendas in order.
So moved by Commissioner Bastien,
Second.
seconded by Commissioner Orbis. All in favor of setting the agenda, signify by saying aye. All opposed, nay. Show the agenda hereby set. Madam Attorney, we're going to get into first reading items. I understand there's just two bifurcations, 4B and 4C. Anyone else wish to bifurcate any items? Seeing none, I'll entertain a motion.
Mr.
from-
Chair, I need to read the titles, please.
Oh, yes, go ahead. Getting ahead of myself.
4A is an ordinance relating to the rules of procedure of the Board of County Commissioners, amending Section 2-1 of the Code, revising requirements relating to notification provided by the county mayor and mayor's designee to all applicable district commissioners of certain matters that originate with the administration, providing severability, inclusion in the code, and an effective date. 4B is an ordinance relating to boats and waterways in the incorporated and unincorporated areas, creating Section 7-40.1 of the code, adopting overnight anchoring regulations, providing exemptions, and providing for enforcement by civil penalty and other remedies, amending Section 8CC 10 of the code, updating schedule of civil penalties to conform to amendments, providing severability, inclusion in the code, and an effective date. 4C is an ordinance relating to passenger motor carrier vehicles, amending sections 31-102 and 31-107 of the code, revising vehicle age requirements for certain passenger motor carrier vehicles, amending definitions, making technical and conforming changes, providing severability, inclusion in the code, and an effective date. 4D is an ordinance relating to for-hire motor vehicles, amending sections 31-83, 31-304 of the code, revising provisions relating to the temporary and permanent removal of chauffeurs from the Ambassador Cab Program, revising eligibility requirements, providing conditions under which chauffeurs removed from the Ambassador Cab Program may regain eligibility to reapply for authorization to operate an Ambassador Cab, making technical and conforming changes, providing for severability, inclusion in the code, and an effective date. And Commissioner Regalado is requesting bifurcation of 4B and 4C.
All right, sounds good. With that, I'll entertain a motion on the two non-bifurcated items, which is 4A and 4D. So moved by Commissioner Bastien, seconded by Senator Garcia. Are you, yep, good with it? All right, it's been moved, it's been seconded. Clerk, please call the roll.
Commissioner Bastien. Yes. Commissioner Bermudez. Senator Garcia. Commissioner Gonzalez. Commissioner Lopez.
Yes.
Commissioner Emiliano Orbis. Commissioner Regalado.
Yes.
Commissioner Steinberg. Commissioner Steinberg? Okay. Chairman Rodriguez.
I vote yes.
Motion passes unanimously.
All right, Commissioner Lopez moves 4B, seconded by Senator Garcia. Clerk, please call the roll.
Commissioner Bermudez. Senator Garcia. Commissioner Gonzalez.
4.
Commissioner Lopez.
Yes.
Commissioner Emiliano Orbis. Commissioner Regalado.
No.
Commissioner Steinberg. Commissioner Bastien.
Yes.
Chairman Rodriguez.
I vote yes.
Motion passes 8-1.
Commissioner Orbis moves 4C, seconded by Commissioner Gonzalez. Clerk, please call the roll.
Senator Garcia. Commissioner Gonzalez.
4.
Commissioner Cohen Higgins.
4.
Commissioner Lopez.
Yes.
Commissioner Emiliano Orbis.
Yes.
Commissioner Regalado.
No.
Commissioner Steinberg. Commissioner Bastien.
Yes.
Commissioner Bermudez. Chairman Rodriguez.
I vote yes.
Motion passes 8-1.
All right,
Mr. Chair, can I take just a moment of personal privilege?
you may.
On 4C, just to let everybody know that there's going to be an amendment coming. We couldn't get it done for that, but there is an amendment coming that I think will resolve any issue. Thank you.
All right, thank you for that clarification.
This was
And I also wanted to, I did not have the pleasure of knowing her, but if we can take a moment of silence in recognition of former Miami-Dade County Commissioner Mary Collins, who has passed away. Thank you, Mayor, for letting me know as well. If we could just join me in a moment of silence for former Commissioner Mary Collins. Thank you. All right, Commissioner Bermudez, I'm going to recognize you for what I understand might be a motion to defer.
Yes, it's item 7D. The applicant and the administration, or the staff, the administration are still having discussions, and there's a request to move it to the July 21st BCC. So it would be a motion to defer to the date certain of July 21st of the BCC.
Second.
All right, it's been moved to defer. It's been seconded by Commissioner Regalado. All in favor of the deferral signify by saying aye.
Aye.
All opposed, nay. Show that item deferred.
Mr. Chair, that's item 7D, and it's 2 supplements.
That is correct. Yes. All right. Public hearing items. Do we have any aviation items, Madam Attorney?
Yes,
Yeah,
we
we
have
can just-
6, Mr. Chair. They each have to be voted on separately. The first one is item 8A2.
Okay, do we want, somebody just want to start moving these, or? Anybody want to start moving the aviation items? All right, Commissioner Gonzalez moves 8A. What is it, Madam Attorney?
8A2.
Okay, so Commissioner Gonzalez moves 8A2, seconded by, can we have some commissioners? All right, Commissioner Cohen-Higgins. We need a voice vote here.
A voice vote's fine.
All in favor signify by saying aye.
Aye.
All opposed, nay. Show 8A2 passed.
The next one is 8A3.
Commissioner Gonzalez moves 8A3, seconded by Commissioner Cohen-Higgins. All in favor signify by saying aye. All opposed, nay. Show it passed.
8A4.
We got to do one by one. 8A4 is moved by Commissioner Gonzalez, seconded by Cohen-Higgins. All in favor signify by saying aye. All opposed, nay. Show the item passed.
8A5.
Moved by Gonzalez, seconded by Cohen-Higgins. All in favor signify by saying aye. All opposed, nay. Show it passed.
8A6.
Moved by Gonzalez, seconded by Cohen-Higgins. All in favor signify by saying aye. All opposed, nay. Show it passed.
8P6.
8P6 moved by Gonzalez, seconded by Cohen-Higgins. All in favor signify by saying aye. All opposed, nay. Show it passed.
Mr. Chair, items 14A1 and 14A2 were not pulled by any commissioners. Do you want to take those up
Move it.
now?
I would. It's been moved by Commissioner Regalado, right? Regalado. We could take both of those at the same time, right?
Yes.
It's been seconded by Commissioner Gonzalez. All in favor signify by saying aye.
Aye.
All opposed, nay. Show 14A1 and 14A2 also passed. All right. Can we go into public hearing at this time, Madam Attorney?
Yes, Mr. Chair. I will go ahead and read those. Item 5A is a resolution amending resolution number R35826 and co-designating that portion of Northwest 25th Street between Northwest 117th Avenue and Northwest 112th Avenue as Our Lady of Guadalupe Street. And its supplement 5B is a resolution approving issuance by Public Finance Authority of Wisconsin Unit of Government of its revenue notes in one or more series in an amount not to exceed $40 million on behalf of Sky Harbor Opelika Airport LLC to fund a plan of finance which includes capital projects located in Miami-Dade County. 5C is an ordinance amending ordinance number 93-5 relating to the Coventry Security Guard Special Taxing District in accordance with the provisions of Chapter 18 of the Code to allow the use of license plate readers or other updated visitor management technology to document visitor vehicles entering and exiting the Special Taxing District, providing severability, exclusion from the code, and an effective date. 5D is an ordinance amending ordinance number 94-151 relating to the Oak Forest Stationary Security Guard Special Taxing District in accordance with the provisions of Chapter 18 of the Code to allow the use of license plate readers or other updated visitor management technology to document visitor vehicles entering and exiting the Special Taxing District, providing severability, exclusion from the code, and an effective date. 5E is an ordinance amending ordinance number 94-68 relating to the Highland Lake Security Guard Special Taxing District in accordance with the provisions of Chapter 18 of the Code to allow the use of license plate readers or other updated visitor management technology to document visitor vehicles entering and exiting the Special Taxing District, providing severability, exclusion from the code, and an effective date. 5F is an ordinance amending ordinance number 95-77 relating to the Enchanted Lake Security Guard Special Taxing District in accordance with the provisions of Chapter 18 of the Code to allow the use of license plate readers or other updated visitor management technology to document visitor vehicles entering and exiting the Special Taxing District, providing severability, exclusion from the code, and an effective date. 5G is an ordinance approving, adopting, and ratifying fiscal year 24-25 end-of-year supplemental budget adjustments and amendments for various county departments and funds, amending ordinance numbers 24-97, 24-99, and 24-102 to make budget adjustments, ratifying and approving implementing orders and other board actions which set fees, charges, and assessments for fiscal year 24-25, appropriating grant, donation, and contribution funds for fiscal year 24-25 in accordance with Section 2-1796D of the County Code, providing certain budgetary reallocations, providing severability, exclusion from the County Code, and an effective date. 5H was deferred to July 21st. 5I is an ordinance granting petition of Lennar Homes LLC for establishment of a community development district generally bounded on the north by Southwest 355 Street, on the east by Southwest 189 Avenue, on the south by Southwest 358 Street, and on the west by Southwest 192 Avenue, Tower Road, creating and establishing San Diego Villas Community Development District, providing for name, powers, and duties, providing description and boundaries, providing initial members of Board of Supervisors, accepting proffered declaration of restrictive covenants, providing severability, exclusion from the code, and an effective date, and its supplement. 5J is an ordinance granting petition of Biscayne Drive Estates Community Development District, generally bounded as amended on the north by Southwest 284th Street, on the east by Southwest 167th Avenue, on the south by theoretical Southwest 293 Street, and on the west by Southwest 177th Avenue, Chrome Avenue, amending the boundaries of the district to expand its total acreage by approximately 54.43 acres, providing severability, exclusion from the code, and an effective date. 5K is an ordinance creating and establishing a special taxing district in the county, generally bounded on the north by theoretical Southwest 215th Street, on the east by Southwest 110 Avenue, on the south by Southwest 216th Street, Haneland Drive, on the west by theoretical Southwest 110 Place, known and described as Palm Bay South Multipurpose Maintenance Special Taxing District, identifying services to be provided, authorizing and directing mayor designee to cause to be maintained and operated by various public improvements, and providing for exclusion from the code and an effective date. 5L is an ordinance approving, adopting, and ratifying special assessment district rates for certain special taxing districts in the county for rates decreasing or remaining flat for the fiscal year commencing October 1, 2026, and ending September 30, 2027, and providing severability, exclusion from the code, and an effective date. 5M is an ordinance approving, adopting, and ratifying non-ad valorem assessment rules, rates, and assessments for 15 certain multipurpose maintenance special taxing districts in the county for the fiscal year commencing October 1, 2026, and ending September 30, 2027, and providing severability, exclusion from the code, and an effective date. 5N is an ordinance approving, adopting, and ratifying non-ad valorem assessment rules, rates, and assessments for certain newly active street lighting special taxing districts in the county for the fiscal year commencing October 1, 2026, and ending September 30, 2027, and providing severability, exclusion from the code, and an effective date. 5O is an ordinance approving, adopting, and ratifying non-ad valorem assessment rules, rates, and assessments for 20 certain security guard special taxing districts in Miami-Dade County for the fiscal year commencing October 1, 2026, and ending September 30, 2027, and providing severability, exclusion from the code, and an effective date. 5P is an ordinance approving, adopting, and ratifying non-ad valorem assessment rules, rates, and assessments for 219 certain street lighting special taxing districts in the county for the fiscal year commencing October 1, 2026, and ending September 30, 2027, and providing severability, exclusion from the code, and an effective date. 5Q is a resolution approving the plat of Biscayne Apartment Central. 5R is a resolution approving the plat of Liminar Estates. 5S is a resolution approving the waiver of plat of 7661 53rd Place LLC. 5T is a resolution approving the plat of Jackson Hospital. 5U is a resolution approving the plat of Upland East. Mr. Chair, 5V, 5V supplement, and 5W relate to a new CDMP standard application before you today for first reading, public hearing, and transmittal. I will read the resolution for transmittal as well as the ordinance title for first reading. The board can vote on the resolution and ordinance together by roll call. If the board decides not to transmit, the ordinance will be deemed withdrawn. 5W is a resolution pertaining to the May 25 cycle application number CDMP 2025-0007, filed by GPC Miami Business Park LLC, requesting amendments to the Comprehensive Development Master Plan, directing the mayor, mayor's designee to act in accordance with the transmittal instructions included in this resolution, related to application number CDMP 2025-7, located on the west side of the Homestead extension of Florida's Turnpike, generally east of Southwest 112th Avenue between Southwest 186th Street and Southwest 196th Street, requesting State Land Planning Agency to review application number CDMP 2025-7, reserving the right to take final action at a later date, and declaring intent to conduct one or more subsequent public hearings. 5E is an ordinance relating to Miami-Dade County Comprehensive Development Master Plan, providing disposition of application number CDMP 2025-7, located on the west side of the Homestead extension of Florida's Turnpike, generally east of Southwest 112th Avenue between Southwest 186th Street and Southwest 186th Street, filed by GPC Miami Business Park LLC in the May 2025 cycle to amend the county's Comprehensive Development Master Plan, providing severability, exclusion from the code, and an effective date. 5X is a resolution approving the plat of Upland West and retroactively authorizing the mayor or designee to file the plat application and authorizing the mayor designee to execute the plat. Those are your public hearing items. I do have some requests to bifurcate. I have 5B, Garcia. 5H was deferred. 5M, I have Milian Orbis, Chairman Rodriguez, and Bermudez. 5N, I have Commissioner Bermudez. 5O, I have Milian Orbis, Rodriguez, and Bermudez. And 5P, I have Milian Orbis, Regalado, Rodriguez, Bermudez. 5S, Senator Garcia. A public hearing
All right. Yes.
You can open the public hearing at the appropriate time. Thank you.
And Madam Attorney, I understand that 5V, 5V supplement and 5W need to be bifurcated as CDMP items as well.
5W and 5V?
5W, 5V, and 5V supplement, yes.
You can take a vote
I'll
on those
bifurcate them and
together.
I'll take them up.
Correct.
I also have, I don't know if I need to do public hearing first, but I also understand the administration's intent is to defer 5P. Can I take that deferral up now, or should I do public hearing first?
It's at your discretion if you want to do the public hearing and then defer, or if you wish to defer.
It's a deferral, so might as well just get it out of the way.
Okay.
I'll entertain a motion to defer on 5P, moved by Commissioner Lopez, seconded by Commissioner Cohen-Higgins. All in favor of the deferral signify by saying aye. All opposed, nay. Show that deferral passed. All right, I'm going to go ahead and,
Chair, is that to the next meeting?
we can do it to the next meeting, yes.
Chairman,
Senator Garcia.
can I release 5B?
Yes, you can release 5B. Well, hold on, we still have to do public hearing, but it's just not bifurcated. Okay. I'm going to go ahead and open up public hearing at this time. When I call your name, I have a few, let me see. Actually, so most of my, let me see how I do this. You know, you'll have a minute to speak, your name and address, and the item you're speaking on, but I don't know if there's like a representative, but all the items are for 5V or 5W, of which I bifurcated, and I'll take up first since it's the only one that people are here for. And it all says 4. Position is 4. I have a few infos, but no against. Is anyone, are you all willing to waive in support, since I see that you're all for? Do you all need to speak? So waiving in support, raise your hand. Okay, any that need to speak? Any that need to speak for or against, that need to speak? All right, so once again, show of hands, who's here in support? All right, hands down. Who's here against it? All right, it's covered. So with that, I will close public hearing. As that is all that I have is only registered for 5V and 5W. And all right, public hearing is now closed. And I will take up 5V, 5V supplement, and 5W first.
Mr. Chair,
Yes,
when we take up 5M, and I want to say something.
sure. I'll let's take up these 3, and then I'll recognize you on 5M.
Thank
All
you.
right. Would you move these items, Commissioner Regalado?
Sure.
All right, so Commissioner Regalado moves 5V, 5V supplement, and 5W, seconded by Commissioner Lopez. And clerk, please call the roll.
Senator Garcia. Commissioner Gonzalez.
4.
Commissioner Hardiman.
4.
Commissioner Lopez.
Yes.
Commissioner Milian Orbis. Commissioner Regalado. Commissioner Steinberg. Commissioner Bastien. Commissioner Bermudez. Commissioner Cohen-Higgins. Chairman Rodriguez.
I vote yes.
Motion passes unanimously.
All right. I'm going to take up item 5M.
Thank
And
you.
you are recognized, Commissioner Regalado.
Thank you. And I know that this impacts several districts, but it also impacts mine, so I'm happy to move it. I've spoken a lot to my residents about these issues, and I was going to make the same comment if we took up the lighting districts, but it appears that we're going to defer that. So I just wanted to take the opportunity to speak to the board that I've made a legislative request that I think is going to respond to a lot of the concerns about these districts. I have a lot of special taxing districts in my area, and it appears that we get more and more requests for them. But one thing is to create them, and the other thing is what happens when we have those increases. Usually when someone calls my office about the increases, we give them the data. Like, for example, the lighting districts, this is what it costs, this is what we're charging you. The county really isn't making money off these things. But I do recognize that there is a need for disclosure. So my legislative request that I just wanted to talk to you all about, and we're going to work on it quickly, is in the same way that I brought an item to the board so that if you have a septic tank, it's disclosed to you when you purchase it. And then I brought another item so that the information on the septic tanks is in the property appraiser's website. I'm bringing an item for special taxing districts. So there'll be a required disclosure at purchase of a home or apartment that has the information on the special taxing district. And then I'm also going to request that the property appraiser include this information so that people who were not there when the special taxing district was created have knowledge and can take this up when they're purchasing it and put that into the considerations as they negotiate a price. A lot of the complaints that I get are not from the homeowners that were there when the districts were created, but homeowners that purchased afterwards that were not necessarily informed by their realtors or by the sellers that there was a taxing district associated with this. They all want the lights, they all want the security, they just didn't know that they had this extra cost. And I think that that would be the most fiscally responsible way of dealing with that, is starting with the disclosure and ensuring that we have that disclosure. I have yet to meet a resident that wants us to turn off the lights. So I hope that we can deal with that when that item returns. But I'm happy to move this item, and I'm working on the other one as soon as possible because I think, especially at the sale point and on the property appraiser's website, I think that knowing is going to eliminate more than 50% of the issues. Thank you.
All right, with that, would you move that item?
I do.
Commissioner Regalado moves
Moves it.
5M, seconded by Commissioner Lopez. Clerk, please call the roll.
Commissioner Gonzalez,
Nope.
Commissioner Hardiman, Commissioner Lopez,
Yes.
Commissioner Milian Orbis,
No.
Commissioner Regalado,
Yes.
Commissioner Steinberg, Commissioner Bastien, Commissioner Bermudez,
No.
Commissioner Cohen-Higgins,
No.
Senator Garcia, Chairman Rodriguez.
I vote no.
Motion passes 6-5.
All right. All right. Let's take. All right. Can I take? I didn't point out all the ones that were bifurcated except for 5M, 50, 5P, but all the non-bifurcated items. Can we have a motion to move them? Gonzalez moves the non-bifurcated item, seconded by Commissioner Bastien. Commissioner Hardiman, you wish to bifurcate an item?
No, I wanted to just have some clarification on the vote, who voted yes and who voted no on the last item. 5M?
The clerk can provide that. I voted no, but it passed.
Okay.
No, I got it.
The nays are as follows: Commissioner Gonzalez, Commissioner Milian Orbis, Commissioner Bermudez, Commissioner Cohen-Higgins, and Chairman Rodriguez.
Okay.
Was that? Okay. All right. It's been moved. It's been seconded by Commissioner Bastien. Clerk, please call the roll.
Commissioner Hardiman, Commissioner Lopez,
Yes.
Commissioner Milian Orbis, Commissioner Regalado,
I'm sorry. Let's start this again.
It's the
The
non-bifurcated.
non-bifurcated.
Oh, the non-bifurcated. Okay. Yes.
Commissioner Steinberg, Commissioner Bastien, Commissioner Bermudez,
Yes.
Commissioner Cohen-Higgins, Senator Garcia, Commissioner Gonzalez,
4.
Chairman Rodriguez.
I vote yes.
Motion passes unanimously.
All right. Madam Attorney, what are the other? I know there's 5M, 50, and 5. Well, 5M we passed already. 50 and 5P.
We have 5N, 50, 5P was deferred, and we have 5S remaining. So NOS.
All right. NOS. All right. So 5N is moved by. I'll entertain a motion on 5N. It's been moved by Commissioner Cohen-Higgins, seconded by Commissioner Bermudez. Clerk, please call the roll.
Commissioner Lopez,
Yes.
Commissioner Milian Orbis, Commissioner Regalado,
Yes.
Commissioner Steinberg, Commissioner Bastien, Commissioner Bermudez,
Nope.
Commissioner Cohen-Higgins, Senator Garcia, Commissioner Gonzalez,
4.
Commissioner Hardiman, Chairman Rodriguez.
I vote yes.
Motion passes 10-1.
All All right, 5-0. I'll entertain a motion on 5-0. It's been moved by Commissioner Lopez, seconded by
Second.
Commissioner Regalado. Clerk, please call the roll.
Commissioner Milian Orbis. Commissioner Regalado.
Yes.
Commissioner Steinberg. Commissioner Bastien. Commissioner Bermudez.
No.
Commissioner Cohen-Higgins.
No.
Senator Garcia. Commissioner Gonzalez.
Nope.
Commissioner Hardiman. Commissioner Lopez. Chairman Rodriguez.
I vote no.
Motion passes 6-5.
All right, and then the last one is 5S, right? I'll entertain a
Yes.
motion on 5S. Moved by Commissioner Bastien, seconded by Commissioner Bermudez. And I believe this is a voice vote, right? Yep, there's a reso.
Yes.
All in favor of 5S signify by saying aye.
Aye.
All opposed, no. All right, show the item passed with one no. All right, is that the last bifurcated item of public hearings?
Yes.
All right, I'm moving to second reading at this time. If any of my colleagues wish to bifurcate any of the second reading items, any bifurcations on second reading?
Mr. Chair, I have requests to bifurcate 7A, 7B, and 7C.
Okay, by?
I have 7A, Commissioner Bermudez and Commissioner Regalado, 7B, Commissioner Milian Orbis, and 7C, Commissioner Bermudez and Commissioner Bastien. And at the appropriate time, I do need to read these titles.
All right, go ahead and read the titles at this time.
7A is an ordinance creating the Miami-Dade County Solid Waste Advisory Board, creating Article 172 of Chapter 2 of the Code, providing purpose, composition, and duties of the advisory board and other related matters, and providing severability, inclusion in the code, and an effective date. 7B is an ordinance relating to zoning, creating Section 33-39.5 of the code, providing for administrative acceptance and approval of covenants relating to the Live Local Act in connection with proposed developments located within transit-oriented developments or areas in the county under certain circumstances, providing criteria, requirements, and procedures applicable to such covenants and modification of such covenants, providing severability, inclusion in the code, and an effective date. 7C is an ordinance relating to the Infill Housing Initiative Program, amending Section 17-124 of the code to limit the number of extensions and time that may be granted to developers under the Miami-Dade County Infill Housing Initiative Program, providing severability, inclusion in the code, and an effective date. And 7E is an ordinance amending the boundaries of the OJIS Sanitary Sewer Special Benefit Area in the county by adding one property, ratifying the non-ad valorem assessment rule rates and assessments for the area for the fiscal year commencing October 2026 and ending September 30, 2027, and providing severability, exclusion from the code, and an effective date.
All right, that's all? All right, I'll entertain a motion on, oh, actually, they were all bifurcated, so the other ones were deferred already and passed, so. All right, Commissioner Bermudez on 7A. You're recognized.
Yeah, I applaud the intent of this proposed ordinance in the sense that certainly regionalism is something we can argue would be great, whether it's traffic and other things. Having said that, this commission has gone through numerous headaches when it comes to deal with, and then many times we've repeated on this dais to our friends in Broward and Palm Beach to try to do some of these things collectively. I'm a little bit concerned that a creation of this board, which is a Miami-Dade County board, will have representation from people from Broward and Palm Beach County when there has been no contribution, at least I haven't seen it, from a really valid discussion on how to work together, despite this body telling the administration and requesting, I think they have done it, by the way, to discuss it, to discuss the issue of solid waste with Broward and Palm Beach. So I'm hesitant because of that, and I don't think, I think the intent is good, but I don't like the makeup of it in the sense, I like the makeup of the fact that we get to appoint them, but I don't like, when you don't have a skin in the game, it's very easy to defer to the largest county. And with the things that are happening, and that we all know are happening probably today or these days in Tallahassee, what are we doing? And that concerns me. Regional cooperation on South Florida Planning Council, certainly with the TPO and the three metropolitan planning organizations, that's a different thing because everybody has the same say. But here we're opening up the door to, in my opinion, two counties that, while they are sister counties, and we certainly should be working together on this particular issue, knowing that it has been a very divisive and difficult issue for Miami-Dade County, there's been no, at least I haven't seen any effort from either of these counties to move forward. So I'm not going to be supportive of appointing individuals that don't have skin in the game, and that in the end it could impact our constituents in the pocketbook and in the future, many constituents down the road, and I'm just not going to be supportive of it. So I understand the intent. The intent may be good, but the end result here I don't think is good for the residents of Miami-Dade County, and I won't be supportive of it.
All right, Commissioner Regalado.
Thank you. I also appreciate the intent, but I have a lot of issues with the item. My take on the tri-county issue is that the makers should consider what we're doing in transit. So currently in transit, we have bi-weekly meetings with the three counties and their departments to deal with SFRTA and other issues. And I think if we wanted to do something with Broward and Palm Beach, we should engage their staff in that way, and that isn't happening. So that's number one. In terms of the layout of this board, there's certain things in the item that are policy determinations that this board has not made. In fact, this board has, on several occasions, discussed diversion and other things that are not represented in this item. We also had an RFI process where different proposals were brought to this board as we began the incinerator conversation. And I met with a lot of those proponents. There were a lot of good ideas that were proffered, and we haven't really gone back to those ideas. So I think this board has a lot of information that we have acquired throughout this process. And I think the right thing to do would be to sift through that information and to also look at our master plan. Miami-Dade County spent a lot of money on a solid waste master plan that has never been brought to this board as anything other than an exhibit, and we've never deep dived into any of that. So before we create yet another group of people to talk about solid waste, I think we need to finish the solid waste conversation on our end. And I'm happy to do that in the committee process. I'm happy to do that in a workshop. I'm happy to consider having staff meet with the other counties. But I think that would be the better path forward. I think here what we're going to do is just create another committee where people are going to have a bunch of other ideas that are disconnected from the department, disconnected from our current reality, disconnected from our contracts, our existing contracts, and in some cases, in contrast with our existing contracts and with the policy decisions that have been made by this board. I'm not a fan of just creating these committees and setting them off. And 9 times out of 10, we create a committee, we waste people's time, everybody has to attend, and then some report comes back to us and we put it in some drawer somewhere and we never really effectuate on it. And I think it's difficult enough for us to get vendors to take us seriously and to negotiate prices without creating yet another hurdle and yet another opportunity for lobbyists for waste management to go and sit and bill, when in reality there really isn't a nexus between what we're doing and this. We have an infrastructure committee. I think that would be the best place to have these conversations. Or we can have a workshop and bring all these folks. You know, when we had the Surfside issue, I used the infrastructure committee to bring experts, and we allowed people to provide testimony and input, and we provided that information to the Florida Bar and to the state attorney when they were working on that, and that was really a better use of people's time. The other issue that we're gonna have is when you set up a committee like this, you don't necessarily get the best in the industry, because the best in the industry don't have the time to commit to this. We just get a room full of lobbyists. So I'm a no on this. I like the idea, but I think this is just going to create more confusion for us as we try to effectuate a solid waste portfolio that is environmentally supported by our residents and also fiscally responsible to our residents. Thank you.
All right, Senator Garcia, you're recognized as this is your item.
Thank you, Mr. Chairman. I appreciate the comments, and Commissioner Bermudez, the reason that we included West Palm and a representative from West Palm and Broward is for exactly that, is to try to bring some regional approach to the issue of solid waste. We know that Palm Beach has done a phenomenal job with their solid waste, and trying to bring some of the expertise from up there down here to see if we can do a better job. That's why I included them into the conversation. There's been conversations at the South Florida Regional Planning Council as to take a regional approach at looking at solid waste. Maybe someone does a better job with garbage, another one could do recycling and so forth. The conversations are continuously being held. But if you feel comfortable, if you're going to vote, if I take that item out, would you vote for the item or no?
You know, I don't have a problem with the board, but yes, if the representation is solely from Miami-Dade County, I don't have a problem with it, because I do believe we should hear from residents on this, and I'm fine with that.
Mr. Chairman, and if I may, just to clarify a couple of points, and I appreciate that, so I'll be happy to amend that out. But I just want you all to understand that this would not be a room of lobbyists, because it's all of us and need to appoint folks. We created the Behavioral Health Board, that we brought in all professionals. I think Commissioner Vicky Lopez understands and knows how good that board is working. The point of this board is to make sure that we have other options, bring experts to the table. It's taken us 3 years to come up with a decision. We haven't been able to do it on the incinerator. We're getting close, but I think when we look at solid waste, it's a much broader conversation that we sometimes don't have the full conversation here at the board. So, Mr. Chairman, that's the item before us. I'll amend that out to try to appease, get Commissioner Bermudez's vote.
All right, so Senator Garcia moves his item as amended, seconded by Commissioner Lopez. And clerk, please call roll.
Commissioner Regalado,
No?
Commissioner Steinberg, Commissioner Bastian, Commissioner Bermudez,
It's amended, yes.
Commissioner Cohen-Higgins, Senator Garcia, Commissioner Gonzalez,
4.
Commissioner Hardeman, Commissioner Lopez,
Yes.
Commissioner Milian Orbis, Chairman Rodriguez.
I vote yes.
Motion passes 10-1.
Congrats. Good work, Senator Garcia. Flip the vote on the dais. I mean, very senator of you. I like that. Commissioner Orbis, you're recognized on 7B.
Thank you, Mr. Chair. I had a few questions to the administration on this. I wanted to ask if these covenants or these agreements, are they currently reviewed by the commission? Do these come to the commission right now? Or what is the approving authority for these agreements currently, if I may?
The administration and or the lawyers are recognized too. I guess she said administration.
Well, I just want to know, anybody, the attorneys or the administration, whoever can answer my question. Thank you.
Commissioner, this is implementing a allowance under the Live Local Act to accept agreements that would set parameters for the development of a Live Local project that is located in a transit-oriented development. There's currently nothing in our code that addresses that allowance. This is providing a procedure for that would both allow the administration through the RER director to accept those administratively, but it also, of course, the board retains the authority to accept those covenants in connection with the zoning hearing or to modify them.
Okay, but is this taking away the authority from our board to review these covenants?
It is delegating authority to accept them administratively, but it's not taking away this board's authority over the covenants to review them at the special exception hearing, to request modifications, or to approve them at that step if they're not accepted administratively. So there is a delegation of authority, but the board still has the authority to approve them in connection with public hearing.
I don't know, your answer is not very clear. So if we approve this, will the covenants come to us or will they be approved by the administration?
Commissioner, they will be able to be accepted by the administration administratively,
Okay,
but this board still has authority to also accept the covenants.
So it does. It delegates authority.
it does, okay.
It does.
Okay, yeah, my concern with this is that Live Local can be modified by the state, right? And this takes away oversight. And today it may be okay, but tomorrow we are delegating a great deal of authority over these developments. So that's my concern. I would like more clarification on this. Mr. Chair, I see that the commissioner is,
Yeah, I think
sponsoring commissioner is
my,
raising
my,
her hand.
my question, and this may shed some light, how is this different than, because I'm following your line of questioning. I get it. So how is this different than how it is today, right? Like today, you enter into a covenant with the applicant, and when the item comes to us, it already comes with a recommended accepted covenant by the administration that then we vote on. Is this a different?
It does include the delegation of authority, as I mentioned, Commissioner, so, Mr. Chair, so it would be for the administration to accept them. The significance of that is the board does not see Live Local covenants until the special exception hearing, which is after the board has already decided whether to allow a property to come into the RTZ. And once they're in the RTZ, the full parameters of Live Local would then apply. So this is a tool, if you will, that would allow for a covenant to be accepted on the front end, which may give some assurances in certain circumstances that
Fair enough.
that could be abided.
Mr. Chair, I still had another question,
Yes,
if I
go
may.
ahead.
Yeah, because, so this is allowing the administration to determine, I mean, I'm reading off the item, maximum height, density, parking requirements, right? So the administration would have the authority to make those decisions for the covenant before it comes to us.
The statute calls for it to be an agreement, so of course this would have to be a voluntary proffer by the developer, but it would allow the administration to accept those or to comment on whether those are appropriate for the area, those parameters.
But it gives the administration more jurisdiction or power over these proposed developments.
There is the delegated authority to
Right.
to determine if that is an appropriate proffer by the applicant.
Okay, I'm still not very clear on this, so I'm not comfortable with it as it is.
Commissioner Regalado.
Thank you. When we passed the RTZ, Live Local didn't exist. So there is a gap in the RTZ legislation. So what happens is if you bring an item into the RTZ, they can avail themselves of Live Local. The reason that the administration has to be given the authority to do this is in order to comply with Live Local. Live Local allows the way that it is set up by the state is that it goes to the administration. So all I'm doing is dealing with the gap between the RTZ and Live Local so that there can be a covenant. Because right now, it's just a free-for-all. So this allows a vehicle in certain areas, because I have gotten requests in my district next to transit for RTZ that's going to be Live Local. So there is no vehicle to contain that request. And once we add it to the RTZ, then they could just trigger Live Local without a covenant, and I want to be able to have the covenant. So this was vetted so that we would not be violating Live Local because we have to comply with the state, but at the same time, if you avail yourself of Live Local within the RTZ, we have a vehicle to curtail and make some sort of adjustments.
Got it. Commissioner Gonzalez, you recognize.
Thank you, Mr. Chair. And I want to thank Commissioner Milian Orbis for the line of questioning, because these are some of the concerns I had. But I think I'm starting to see the big picture here, right? If I could get the director to come up for a second, through you, Mr. Chair.
You're recognized for an ebb and flowing Q&A.
Director, I'm just seeking clarification, right? So as it stands now, we would vote on this rapid transit, and then afterwards, we would then get the covenant after we vote? Is that how it happens now?
So the way in which properties enter into the RTZ, you do separately bring those parcels as legislative considerations, ordinances before you. So that is the first step of a property entering into the RTZ. Afterwards, then they would follow through with whatever process would apply to their site in terms of actually getting site-specific zoning.
Got it. So the site-specific zoning would be attributed to the covenant that we're talking about here. What this would do is bring it ahead of time, but we still vote on it. Because I'm trying to follow where this is going.
It could be. I think it does depend on the circumstances of each parcel. The intent at the state level when this was approved was to enable jurisdictions to have greater control over what was occurring in transit spaces, which, you know, that it was viewed as a benefit at the time. And to the extent that, you know, we have the ability to negotiate with folks on, you know, certain parameters that then make the development overall be, you know, compatible, more compatible with the area, contributive to transit. That was the intent, to give some space for that.
Understood. And I guess the only thing I'm trying to understand to get there is, if this were to pass, it would give you the authority to accept the covenant, but that doesn't mean that the covenant is then enacted, right? Does that, or does it? Does it then come to the board with the covenant in place and then we vote on it?
No.
So you would have the authority then to accept the covenant and enact it?
Yeah, recall that Live Local already removed our authority. So, you know, they would be administratively approved. That's why, from the perspective of providing parameters for local control, this was viewed as being beneficial to attaching, you know, characteristics to the commitment and obviously accelerating the development of affordable housing.
Okay. Thank you.
So to clarify, Director, just from my understanding too, is, so if I understand correctly from Commissioner Regalado's explanation and what the attorneys said is, today, absent this item, we cannot enter into a covenant with said properties. We don't have jurisdiction to enter into a covenant today based on Live Local. That's what I understood from Commissioner Regalado's explanation. That this will give us the vehicle to be able to even enter into a covenant today. We cannot do that. It's literally what Commissioner Regalado just said on the record. So,
Right.
why is everyone looking at each other like to the director?
If we could hear, please, from our Director of Zoning.
Yes, this will give us the opportunity to get those covenants before the applications are even brought into the RTZ.
Okay, that's not the question. So I'll repeat the question. The question is, today, absent this item that Commissioner Regalado has sponsored, 7B, you all, the administration and or this body, cannot enter into a covenant with those properties.
The covenant can only be entered at the time of the special exception, the hearing. The voluntary proffer of the covenant could occur in the special exception hearing.
Okay. And with this, it could be entered into without a special exception hearing?
Prior to the hearing, they could submit the covenant to us administratively.
Got it.
Covers the gap.
Okay. All right. Fair. Now, second question is why not, maybe to the maker of the item, why not so that covenant comes to this board, and why accept it and enact it administratively? Which I think is where like some of my colleagues were going, so I'm just trying to say it out loud.
So the issue is, when you bring something into the RTZ, you know, you don't deal with this. I don't want to be so prescriptive because something might come into the RTZ and they're saying that it's not going to be live local, and then later on they decide to be live local, right? So the way to cover the entire gap is to say you can bring it when you bring it into the RTZ, or you can bring it after, because the property might change after you bring it into the RTZ. So the way that it's drafted covers the entire gap. You can always get a covenant if it's going live local, because you may not know when you bring it into the RTZ that it's coming live local. Example, in the city of Miami, we're still in litigation, right? So those projects are not happening because that litigation hasn't been resolved. So those properties came into the RTZ, but they could decide to go live local, right? And then now we don't have a way to effectuate any sort of covenant unless they come in for an exemption. So
Commissioner,
this just covers the gap.
So would you be open to a friendly amendment of somewhat mirroring the CDMP process, where like the administration can enter into the agreement, but it be ratified by the board?
The issue is that it's live local. So I don't want to be in violation of the statute. Because it's live local, it doesn't require ratification of the board. I mean, if they need a variance, then live local comes to us. But the whole point of live local is that it doesn't come to us, which is why we have the gap.
So to the lawyers then, is how is it that there's a disconnect for me? How is it that the administration can, like, we're a government, right? The way that the statute, unless the statute is written very specific, which I'm sure it might be, but we're a government body. So how is it that the administration can enter into a covenant, but the board cannot?
Mr. Chair, so the statute calls for the agreement. This is a vehicle for it. As Commissioner Regalado explained, the reason for the delegation of authority for the administrative acceptance is it's a function of the timing to ensure that there's a covenant in place at the time the board brings a property in to the jurisdiction and before, up until the point of the special exception zoning hearing. However, this board still retains the authority to approve those covenants at that time, or to approve changes to those covenants at that time.
Okay, that's what I'm saying.
You still have that authority to approve covenants in connection with the projects at that time. The administrative acceptance allows for there to be that protection in place before you all have an occasion to see a covenant.
Okay, but can it come to the board for ratification?
If they're having the hearing, isn't it coming to them?
It would come, so it would come to the board, and if you all wanted, so look, I don't think ratification would be the word of choice, because we want to make sure it's in place. But if you want to have something in this that says the board may, expressly says the board may, consider those covenants as well at the special exception hearing, then I think that would just make explicit what your authority is as well.
I'm fine with that. I just, so the way that live local is written by the state is that it is completely administrative. Every now and then we get live local that has variances, so it comes to us. I'm fine with that, but we drafted it because we didn't want to violate the statute, because we are preempted from taking a position on live local. The reason that we're able to do these covenants is because you're availing yourself of two things, the RTZ and live local. The fact that you're availing yourself of the RTZ allows us to have input into the live local process.
At that point.
So I'm happy to amend it that way, but just so that you understand, it's giving us more, I want to be careful of my, it's giving us more input, and not less, because there's a gap. There's a world in which you bring something into the RTZ and then it goes in another direction, and you can't undo that. So, but happy to modify it.
I'm good with it, with that light. Okay, go ahead, Commissioner
Well,
Steinberg.
I think what you're trying to also stop is like the bait and switch.
Yes, right. Yes, of course.
However, what other protections can we put in? Are there any other additional safeguards? Because this is actually, you're touching on a very important issue that affects a lot of our residents. They're not very happy, and so I want to make sure that we're looking at this through that lens of what other safeguards are, what other tools in our toolbox, what other safeguards can we put forward?
Again, this is only in the RTZ because it's the only space in which
We can have that.
we can have the input. So that I just want to be clear
Because of
on
the
that.
RTZ.
Yeah, because of the statute and the way that the statute was written. So, yeah, this is, well, it creates a gap because we as a board are providing a zoning benefit. and then someone is availing themselves of that zoning benefit. So as a result, we get to do this. So I'm happy to amend it like that, but I don't want to go further than the RTZ and other things because, again, I want to solve this particular issue that we're having.
Yeah, I'll just finish by saying, look, obviously we need, the affordability crisis is a big issue and we need proper housing, right? So we just need to make sure that we're looking through the lenses, is this actually working? And is there an opportunity to have it come back to us at a certain time frame to do a look back and see what the trajectory is, where we're going with this, maybe build that into her as a friendly amendment?
Yeah, Mr. Chair, I would, on that, if I may.
Commissioner Orbis.
Not to the director, you're wonderful, but you're not always going to be here, right? So we need safeguards to make sure that we're not going beyond what our community needs and wants. So it would be, as Commissioner Steinberg said, some safeguards around the parameters that are allowable. And I would feel more comfortable if the commission has review.
So I thought, to the attorney, I think that's what my amendment does to the extent that the law allows, right?
Exactly, to the extent that the law allows. Please.
So it's either we got it to as far as the law allows, or we just don't do this. But to the attorneys, and I'll recognize you, Madam Mayor, you can, while the attorneys kind of gather their thoughts on that, you're recognized.
Thank you. Lourdes Gomez, our Director of RER, suggests, and I think it's worth consideration, that we notify you when there's a Live Local application in your district. So that would be at the front end, so you would have an opportunity to weigh in.
So, Mr. Chair.
I think, yes, yeah.
Mr. Chair, about that.
Yes, I think that certainly that. I wonder if we should go as far as,
Ms.
like when there's any Live, because some of these are like larger county-wide like.
We do, you passed a resolution directing us to notify your offices, and we have automated that when we do have a Live Local application that enters our system. You receive an electronic notification.
And remember, Mr. Chair, you and I did like a sunshine meeting and we created a website. There was like a whole thing. So there's a website, we give people access to the website, they can see the application. So when Live Local first came out, we really tried to provide disclosure to folks. But again, this is about the gap with Live Local and the RTZ, which is a separate kind of situation.
Mr. Chair, sorry, I just want to add one more thing. This is another part that gives me heartburn. Section D says the covenant may be thereafter modified administratively. So can that part be limited? Because that means that we can review it, and then after the administration can modify the covenant to their liking. And it says the modification may be approved by the BCC only after public hearing. So that gives a lot of discretion to the administration, and that whole section really gives me heartburn. So that would be my 2 cents. I think that last section needs to be limited.
So to the attorneys, I think the general feedback is, how far can we go within the state statute for this body to have further say? Like what's the furthest you can go without encroaching or violating state law?
Through the chair. Mr. Chair, one additional thing that I think this board could do as part of this ordinance would be to provide that for any ordinance bringing a property that proposes to bring a property into the RTZ, which of course would be a discretionary decision of this board, this ordinance could provide that the existence or lack thereof of the covenant contemplated here would be required to be disclosed in such item, and any such covenant would be required to be attached to that proposed ordinance. And then it could, this additional language could go on to just provide that whether, of course, to bring such property into the RTZ would continue to be it's a discretionary decision for this board. So then when this board hears an ordinance to bring a property into the RTZ, it would come to this board together with the covenant that would have been accepted by the administration. If it's then not acceptable to this board, it would be within the authority of the board to not approve the ordinance and not bring that property into the RTZ.
I like that, but for the fact that I think that, because Commissioner
Your
Regalado said a
incentive-
point where like some may come into the RTZ with one idea and then they may shift courses, but they're already inside the RTZ. They don't come back. Now, what happens in that case is that covenant would still apply regardless of even ownership change, right?
Yes, that's correct.
Mr. Chair, thank you so the issue is we don't want to incentivize people to not tell us that they're going live local to get into the RTZ in order to get out of this. Personally, I've been very clear in that I want this done during the RTZ process, but it's up to every commissioner. Again, you all have to deal with your items, right? I don't want to create a situation where they're going to say, oh, we're just coming into the RTZ. And then once they're in the RTZ, they're like, oh, now we're going to do live local. So that's why I was very careful in that a lot of things can happen in that time period. And what's in the item is just the state law. The state law currently says that anything and everything that is live local is done administratively. That does not mean that we as commissioners do not participate. We do. You and I had a sunshine meeting. We talked to staff. There's a website. Like within the parameters of what happens, right? There is some level of participation. Now, usually there is some other variance that brings the item to us. So more often than not, it comes to us. I just don't want to create a situation where we're incentivizing people to kind of do it on the back end instead of the front end. But if you all feel comfortable with that, so be it. Then are you going to take it out of the RTZ, right? Are we then going to create and if it goes live local, then are you going to pull it out of the RTZ? Because now you're saying that in order to come into the RTZ and be live local. So I just don't want the state to consider any of this as a limitation on their preemption. That's my concern. I think that it's well drafted. It only deals with the RTZ. It's very clear on that. That is a benefit that is being proffered to the property owner. And we just want clarity. And I will say this, staff drafts covenant all the time. I've never seen staff, go somewhere with a covenant that does not involve the commissioner of the district, right? And a conversation about that. They have no agenda other than following the code and doing what's right for the residents of Miami-Dade County. So this idea that they're going to run and approve a covenant, I've never seen that happen. But again, this was the way that the statute was created, and this is how Live Local works. This is just covering the gap.
So I guess the question on that proffered option, Abby, and that, because I understand both, like what you're both saying, and that's why I brought it up, is so we cannot impose a covenant on these properties because of Live Local, but can the applicant or the property owner propose a covenant of their own? Like, can they willingly do it?
Only with this.
So go ahead.
Through the chair, yes, I think one of the problems I think this ordinance is attempting to solve is more of a timing issue. When this board has it before them, an ordinance to bring a property into the RTZ, that ordinance would go into effect within 10 days. If at that time an applicant were to proffer a covenant, the covenant may not even be recorded before that, before that ordinance goes into effect. And so I think one of the things this ordinance would do would be to allow for a covenant to be accepted administratively, so it would be in effect, recorded in the public records, and in place at the time when the board is considering the discretionary proposal to bring a property into the RTZ. It's a little different from when the board is sitting in its zoning capacity or in its CDMP capacity.
No, I get it, Abby. But I asked that question I knew the answer to that, but I asked that question to clarify because then the gap that I saw when in that option, that last amendment option that Abby proffered or suggested, I guess we can't force them to come back to us, but if there's a covenant tying them to one thing, they will on their own want to come back and do a new covenant. I guess it's not like there's no harm done, right, in that sense?
Well, that's if they came in and they said they were doing Live Local and then they decide not to do Live Local. That doesn't answer the incentivizing of coming in, doing RTZ and not saying you're doing Live Local and then doing Live Local. But listen, that's fine. If it becomes a problem, we'll just fix it then. I think now we just need to get her going. We can always fix it later if it becomes a problem. This took a lot of time and effort to draft, so I'm happy to amend it with Abby's suggestion and move forward and call the question.
All right, show it. Well, I have a few colleagues that want to speak, but so show it amended as per the first amendment and per Abby's suggestion. Commissioner Hardiman, Orbis, you technically had the floor.
I have a question.
Go ahead, and then Hardiman, and then Cohen-Higgins.
I appreciate your work on this, Commissioner. In the last section D, it says the covenant may be thereafter modified administratively, et cetera, regardless of whether such covenant was accepted at a public hearing or in connection with prior zoning action. Can you explain that?
You may.
Through the chair. So Section D does mention the administrative modification as permitted in 33.310.1. And I would ask the director to confirm this, but that section speaks about very limited circumstances under which covenants may be administratively modified, like where the conditions of the covenant have been complied with, where there's been like some type of scrivener's error, where the conditions have become moot. It is, I don't know if the director would.
So, but question, if it's heard at a zoning hearing, at a public hearing, and it was not accepted by that body, the director has the authority to go ahead and override the decision of that body to not accept the covenant and go ahead and move forward with it.
No, Commissioner. I mean, the conditions in there are just those very limited conditions that can be administratively modified, but it's not speaking about overriding a zoning board's decision.
Well, it says they can modify a covenant regardless of whether such covenant was accepted at a public hearing.
Right. May I defer to the director?
Through the chair. So this section of the code allows, currently right now, we can administratively modify covenants for certain things, certain small things like increase one story, add 10% of the trips. So this section D refers to that current existing section of the code to let us do the same administrative modifications.
Okay, does that interfere with the Live Local law? Like, does that need to be there? Can we remove that portion?
Commissioner, you don't have to have the allowance for the administrative modification.
Yeah, that would be my friendly amendment there would be to strike that, because I think that gives too much leeway there. And I'm okay with the other amendment. Thank you, Mr. Chair.
Thank you, Commissioner Hardiman.
I'm happy to do that. I mean, normally it's a scrivener's error. I mean, the only thing that I would say, I'll take it out, but then if they have a scrivener's error, then it comes back. So just so that we know that then the item comes back, but happy to take it out to make everyone feel better.
All right. Very, very amicable today, Commissioner Regalado. I like it. I like it. Keep it up. Commissioner Hardiman, you're recognized. Hopefully this time.
So I'm just trying to understand why we're here, right? So if you walk me through this process, for instance, not all of our districts deal with RTZ items, right? For the most part, there are certain districts that deal with RTZ items. Currently, right now, if a property owner wants to bring his property within the RTZ, district commissioners ask for legislation to be written for the property to be included first, right? We debate this issue and pass it. Is there or is there not, well, as I understand, no covenant necessarily is written at that time. So how is this legislation effective? Because in that part one, and then two, I know that once the property is in, for instance, the RTZ, they usually come up with a development project. And then that's when typically we've seen a lot of the covenants and agreements come into play. If there were public benefits, if whatever it may be. Is this a step in between that? Is this getting rid of that? Like how does this legislation affect the overall process that we have today?
Through the chair. Commissioner, this is really about a kind of a parallel process. The process that you described where there's first the item bringing in a property into the RTZ, would remain. And then the typical projects that this board sees at the special exception hearing, those would still come to a special exception. Today, if a property owner wants to proceed under Live Local, then depending on their plan, whether they, for example, might need certain variances that aren't part of the Live Local provisions, they might still have to come here before this board for public hearing. But they might be eligible for just administrative modification today. For those properties, when this board is making the decision to whether to bring them into the RTZ, that's still a discretionary decision, but you're correct that this board doesn't have a covenant that's been proffered to Miami-Dade County at that stage. And so this ordinance would enable a covenant to be proffered administratively and accepted by the zoning department before the board considers that legislative action to bring a property in or not. If a property is located in a city and hasn't been brought into the RTZ, it's possible that under city zoning, they may be eligible to proceed under Live Local. But once they become under the county, once they're under county jurisdiction, if they wish to proceed under Live Local, arguably the height that we have authorized may in some cases be significantly higher than the height that would be applicable under Live Local, where it's under the city's jurisdiction.
So in that case, then it would be a bad thing for us to bring them into well, I guess it depends on whose ox is being gored, right? So if you're saying the height is higher, which is a major benefit to that property owner versus the height being lower, because that will be a loss to that property owner versus the neighborhood. The neighborhood may say that height maybe is too high. So that's why I said it depends, right? But what I'm trying to understand moreover, and maybe Commissioner Regalado will help me after they've given this description better, is typically the covenants that we're entering into, the agreements that we come to, once the property is proposed to be developed, those are of greater sort of nature. They are more significant than any agreement that we've done necessarily than any other type of agreement. So if a property owner wants to be included in the RTZ, what you're proposing then with this is that they have some sort of proposed covenant before we're actually hearing the item, so we have some agreements. And if so, would you then require or ask for them to provide their public benefits or their statement of public benefits at that time? And say, for instance, they do. What you're telling me is that they can still pivot and not act on those covenants or in concert with those covenants?
Commissioner, the covenant that I'll see if I can, hopefully I'll answer your question. But the covenant that we're talking about here in this ordinance is pursuant to a particular state law allowance that's in the Live Local Act for transit-oriented development, where the statute allows us to enter into an agreement with the property owner with respect to certain parameters such as height and density. So it is a particular paragraph in the state law that that the county could avail itself of. I think it's unclear in terms of including other additional things that aren't referenced in that statute. In terms of its enforceability, assuming that the county has regulatory authority over that property, the covenant can be written in a way where it's enforceable. It just continues to be enforced, and it's not necessarily limited to whether that property owner is exercising live local or not. But if they're not exercising live local, then you're correct that it would very likely come before this board just through the much more typical special exception process, where you have a full public hearing and you're typically receiving additional proffers in a covenant.
Even with Mr. Chairman, say the statute talks about density and height, there are many times in which we do tie public benefits to additional height and density. Is that within the scope of the initial covenant?
You're right. Anyone could answer his question, yeah.
If they proffer, so this doesn't prevent us, again, bringing something into the RTZ is a benefit. So if they whatever they proffer, this just allows us to do that. And by the way, it doesn't just have to be about height and density. It could be that where that municipality is, it takes forever to effectuate live local, and they would rather do it with the county because the county's faster. So it doesn't necessarily have to be about the size of it. Sometimes it's about the speed of it or the process of it. So this doesn't prevent us from doing more if everyone's okay with it, right? We have to be very careful with live local in that we cannot impose, but that's why this is the nexus of RTZ and live local, right? So whatever, you request on the RTZ side can now be effectuated in a covenant, right? So that's the issue that, and look, whenever I bring an RTZ, I sometimes I add an MOU, I try to beef it up so that it doesn't get done later, but that obviously takes a lot of time. I wanted to provide a vehicle so that could be effectuated in that period. So, because it is just more than live local. So live local, we track the statute, and that's what it is, right? But what we're saying here is this combination of things, the live local and the RTZ can beget a covenant.
Okay, Mr. Chairman.
Through the chair.
The last thing I'll say is, it sounds like something we need, and then I also appreciate the adage that Commissioner Milan-Orbis added, because I would hate to have things that we included dismantled, if you will, by the administration because they don't necessarily agree with what we did. They wanted something a little different. So I'm agreeable to that as well. Thank you.
Through the chair.
Yeah, Madam Mayor, sorry.
Thank you, Mr. Chair. So the way the staff have explained this to me, and it's consistent with the intent of Commissioner Regalato's item, is that this makes sure that the county has leverage. And this has been a very productive discussion with a lot of information shared about Live Local. It would be very helpful to us if the item could be deferred so that we could have a chance.
No, please.
No, okay. Just to be clear, we are concerned about eliminating the ability that we have to frame a Live Local application for the best interests of the county. Lourdes, if you don't mind, can you please amplify on the point?
You may amplify, Lourdes.
Oh, certainly, what I explained to the mayor was that right now, Live Local is a preemption on our control. This is providing us a mechanism, as has been explained, to insert parameters that are beneficial to the development that we otherwise do not have a vehicle to effectuate with the developers who otherwise just have the right to go to permit under the parameters that the state statute gives you. So that's why, the social equity statement characterizes this as a positive, because right now the one clear benefit of Live Local is acceleration of affordable housing. What this is doing is providing a vehicle to ensure that some of our local rule desires are manifested in that development. That is how we see it. Not barring, it is a site by site, so I apologize if the answers have been confusing, because the reality is, like with every zoning decision, it depends on each site. It depends on the history of each site. There may or may not be a pre-existing covenant. There's a whole host of factors that go into a specific zoning site. But in general, that is the benefit of this. It's giving us that mechanism to do the things that we would be asking for as part of the normal course in our code.
All right, Commissioner Regalado for a response.
Thank you. Madam Mayor, I appreciate that, but I've worked on this a lot with staff. And if you all want to bring an item about Live Local, you can. Have at it. This is about the RTZ and the nexus between the RTZ and Live Local. And I don't want to muddy the waters by turning it into a whole Live Local thing, because it's not. We are very limited in what we could do on the Live Local side. This is very specific about the RTZ. And to Commissioner Hardeman's point, we all bring these items. The commissioner of the district brings this item. And in that item, we get to establish what we believe is important for that particular site. It's still a zoning application. So I don't want to add a bunch of stuff that it may or may not apply to that particular site. It's a very specific thing. And I am very thoughtful about every item that I bring into the RTZ. And I look at the site, the impact, and all of it. We currently have this issue with the RTZ and Live Local, and I think we should solve it sooner rather than later, and not turn this into an omnibus item about Live Local, because it's not. It's just specifically about the RTZ, and it has a lot of clarity, and the administration gets to weigh in. When the RTZ items are presented, the administration gets to weigh in if they want to weigh in. They get to do it before it comes to the agenda, before we vote on it. So they already have the opportunity to do that on a case-by-case basis. I do not want to create a litany of other things that then we have to consider before we even bring these items. And if we want to do that, we can do it amending the RTZ, right? So that it applies to all RTZ. This is very particular to RTZ and Live Local. So if there are priorities and considerations that the administration wants for the entire RTZ, it should be done in the RTZ item, not in this particular item, which is about Live Local and the RTZ.
All right, Commissioner Cohen-Higgins, and when she's done, Commissioner Gonzalez.
Thank you, Mr. Chair. I have uneasiness and unreadiness on this because, and again, I'm paying very close attention to the conversation as it carries forward. In the whereas clauses, it says here, it introduces Live Local, and it says, however, the statute also provides that for proposed Live Local developments located within a transit-oriented development, which is what we're talking about now, or area, the applicant and the county may agree to development parameters for the project that differ from what is specified in the statute regarding height, density, floor area ratio, and parking. That's what we're talking about. My question is, the same way that this item is drafting a law saying administrative acceptance of covenants in this very narrow and in circumstance, i.e. transit-oriented developments and Live Local, can't we write a law that says something different? Can't we write a law that says that we, as the county, because it says in this section that I just read that the applicant and the county may agree to development parameters of the project that differ, can't the county in that reference be us, the board, as opposed to you, the administration? So similar, I understand that we're not going to run afoul of Live Local, but I understand that there is a gap. So why are we writing the gap such that the administration has the authority as opposed to us? Why can't we write the exact same statute giving us the authority as opposed to yourselves? That's my question to the lawyers or to staff. This to me seems like an opportunity, and I recognize it because it's been said. It gives us some level of control regarding these applications that everybody recognizes tends to be rather controversial throughout the county and in our district. So why would we as a board yield that little sliver of authority to you as opposed to us when we are the ones that are representing single districts and know these and would be the best ones to say this covenant is great or this covenant doesn't go far enough, which is what I think Commissioner Hardiman was addressing. You know, whether it's a community benefit or whatever the neighborhood may need, why wouldn't we want that for us as a board? It's not a philosophical question. It's really a question of, can this be drafted in the opposite way? Can it be drafted such that the board has the authority? It's kind of yes or no.
Through the chair, Commissioner, I think something like that could be done where it's for the board. However, I think we may want to think about how the RTZ ordinance, typically those are just ordinances that come in through the legislative process and there's not like a zoning public hearing. We may need to think about how that could be structured with that so that that ordinance would not go into effect unless or until the board has the covenant recorded in the public records and in its final form. So there may be kind of a mechanics question that in terms of the how, but whether it can be done, I think the answer is yes.
Okay, so if the answer is yes, it can be done, and the concerns that I've heard from my colleagues are pretty consistent, why would we yield this and delegate this authority when we could write a law that retains it with ourselves? And if the answer to that is yes, and I understand it may be mechanical, and I understand that there's been a lot of time spent on drafting this ordinance, I personally would prefer to keep that authority. And again, it's the only sliver of authority we have left under Live Local, as stated in the item. And so as it's written now, I won't be supporting it. Thank you, Mr. Chair.
Mr. Chair. Thank you, Mr. Chair. And I want to thank Commissioner Cohen-Higgins for that line of questioning, but also Commissioner Hardiman, because I think he did a good job at getting to I guess, the meat and potatoes of what we're talking about here. I think Lourdes did a phenomenal job at kind of clarifying the issue. I think that there's an easiness with the board. However, I think that this is an important item to Commissioner Regalado and Commissioner Hardiman's point. It seems like this is something that's very important. The mayor has requested for a deferral. I'm going to motion to defer the item. And if I have a second, the reason I would be motioning to defer the item is so that we can have perhaps more time to fully digest what authority, if any, we are letting go of, because through all the line of questioning, I think the consensus here is we would rather not delegate authority. But the way that I understand it after the director explained is that perhaps this just facilitates that authority. So I'm going to go ahead and I'm going to motion to defer the item respectfully, Commissioner. I think that it's a well-drafted item, but I'm going to motion to defer the item, and if I can get a second.
Second.
All right, it's been moved to defer. There's a second on the deferral. Any discussion on the deferral? Sure.
Defer to when? To come back?
Defer to, if it was to be deferred.
I want to speak on the deferral.
Sure, but if it was.
And if it
go
were to
ahead.
be deferred, obviously to the next meeting.
Okay.
First of all, you've amended the item several times here, and I've accepted every single amendment. And the statements that have been made are in conflict with the amendments that I've accepted. So yes, we can contort the item and put it on a hinge and make it completely different. But I accepted the amendment that said that everything comes back to us if it's legally permissible. I accepted the amendment that said that no changes occur at the administrative level. So you're all still talking about issues that you have on an item that you've amended that I've accepted the amendment to. So if you want me to defer it to add that, I'm happy to do it because I've already accepted those amendments. But what I don't want is to defer it and then to have the item rewritten again when it comes before the BCC. I did not effectuate Live Local. There is a gap. We have a problem. We cannot declaw Live Local inside the RTZ because we will be sued by the state. It was mindful and it was thoughtful as presented. There are a lot of things that we can do, but we can also be sued for those things. Live Local does give us heartburn, but it is the law in the state of Florida. And I am trying to provide us a vehicle so that people cannot take advantage of the RTZ with Live Local. In our current state, every item that we bring into the RTZ can be morphed into a Live Local, and this board can do absolutely nothing. And I do not think that another day should go by without us being able to change that. If you want to take more time to think about it some more, that's fine. But just to be clear, this is about giving us authority, not taking away authority. And this constant mistrust of the administration and our staff, I don't understand it. Because we are the commissioners that bring the item. We are the commissioners that bring the item. We are the commissioners that bring it into the RTZ. Staff does not bring items into the RTZ. We are the commissioners that bring it into the RTZ. So if there's an issue with the RTZ, then we can always amend the RTZ. I have amended the RTZ. I brought 3 items amending the RTZ. I amended the RTZ for the impact, the impact fees. I've amended it, and we can continue to amend it, and we can add more things to it. But in this particular area, there is a gap. And I'm just trying to provide us access to a vehicle to respond to that gap. Because currently we are exposed. And because we are exposed, our residents are exposed. And if our residents are exposed, we are then the ones that facilitated them being exposed. Thank you.
So I will recognize Commissioner Lopez. Go ahead, Commissioner Lopez, on the deferral.
Mr. Chairman.
We're on the deferral now.
I've really appreciated all the comments here. I think I know Live Local probably better than all of you. And I want to first appreciate the fact that Commissioner Regalado.
You don't have to rub it in.
Sorry. I appreciate Commissioner Regalado attempting to fill a gap that I'm painfully aware of, since most of my development comes to the RTZ. And I too want to secure that they can't make the bait and switch, as Commissioner Steinberg said, which they do. I don't think that I would be giving up authority here at all. And somehow, I don't know how this got convoluted into, we don't love Live Local and we want to try to figure it out using this vehicle, which would be, I think, a grave mistake. Here's what I think, and I understand, Commissioner Gonzalez, that you think a deferral would help, but I actually want you to know that I'm prepared to vote on this, yes, in the affirmative, because the gap is real. And I prefer to know what the covenants are prior to it coming to me to make a decision on whether or not I'm even going to accept them into the RTZ. It's a safeguard that doesn't exist now. And that is why, I can support this item. I don't know that we should spend much time arguing about, the merits of the Live Local. What we are arguing about here is very specific to any project that comes into the RTZ. And there is a gap. And I agree with Commissioner Regalado that I'm getting more control by doing this as opposed to losing control. So I just want, I waited and I listened and I listened and I listened. And then I said to myself, at some juncture, and I thought your closing remarks, Commissioner Regalado, were clear and concise enough for me to just say, I can support it right now. I think deferring it doesn't do anything. And I appreciate you taking the amendments that address some of the concerns that our colleagues have with this. But I don't know that a deferral makes sense, because it's either this or, in my opinion, nothing. And we go back to me having this angst around the gap and watching people play with it to our detriment. I like more transparency. I like it sooner in the process than later in the process. So I just wanted to give you the benefit of my comments and what I have also experienced in bringing in projects into the RTC. Thank you, Mr. Chair.
Thank you. So, look, well said, and well said, Commissioner Regalado. Look, I personally, look, I could support the deferral just because I understand that they just need more time to understand it. I see every item before this point. I read and get briefed on it at least 3 times before we get to this point. So I'm comfortable with the item, especially with the amendments that you've agreed. So I'm prepared to vote and support it today. I'd support the deferral only in the event like that they might need more time to just understand it. Again, I'm comfortable with it. With the item, I'm comfortable with deferring it till the very next meeting and you all just getting further briefed. It's really the will of this body, but I can do either. I appreciate the friendly amendments. You're right. You did concede on a lot of things that I think are good amendments, but I do appreciate you for accepting them as friendly amendments. Look, we have a deferral and we have a motion to defer in a second. You can speak on it. Commissioner Gonzalez.
So I agree. I'm comfortable with the item, but I do see some uneasiness from my colleagues. I would hate for this to move forward for a vote, and because of uneasiness, for it not to move forward without everybody understanding it completely. I'm comfortable with voting. If the will of the board is to vote today, I will withdraw my motion to defer. I'm comfortable with voting right now, but I would hate for this to fail because of uneasiness.
Okay, so Commissioner Bastian.
Thank you, Mr. Chair. I've been listening with attention, and I'm not going to make a long speech, but I agree with Commissioner Regalado. I think she's agreed to a lot of the amendments, and I'm ready to vote. If there is anything that can be anything specific right now, that can be that she can answer, let her clarify it. From where I am right now, I'm satisfied and I'm comfortable, especially after listening to Commissioner Lopez. I'm comfortable to vote now. And if there is any clarification, let's make it and move it forward.
All right, so with that, Commissioner Gonzalez withdraws his deferral. We'll take a vote. I mean, what's the worst that could happen? So we have a motion by Commissioner Regalado to move her item as amended, I think 3 times. You got all the amendments. Second. This gives us more protection. Yeah, we've established this gives us more protection.
Second.
Seconded by Commissioner Lopez. Do I need clerk, please call the roll.
Commissioner Steinberg? Commissioner Bastian? Commissioner Bermudez?
Yes.
Commissioner Cohen-Higgins?
No.
Senator Garcia? Commissioner Gonzalez?
4.
Commissioner Hardeman? Commissioner Lopez?
Yes.
Commissioner Milian Orbis? Commissioner Regalado?
Yes.
Chairman Rodriguez?
I vote yes.
Motion passes 8-2.
Thank you.
All right, and then as amended.
As amended, and amended, and amended.
All right, so I did have one that wasn't bifurcated. We could take that up. Mickey Steinberg moves 7E, seconded by Commissioner Lopez. I mean, it's your item, so if you don't want to move it, I mean, I'm happy to have someone else move your item. It's seconded by Commissioner Lopez. Clerk, please call the roll.
Commissioner Bastian? Commissioner Bermudez?
Yes.
Commissioner Cohen-Higgins?
4.
Senator Garcia? Commissioner Gonzalez?
4.
Commissioner Hardeman? Commissioner Lopez?
Yes.
Commissioner Milian Orbis? Commissioner Regalado?
Yes.
Commissioner Steinberg? Chairman Rodriguez?
I vote yes.
Motion passes unanimously.
All right, Commissioner Bastian, you're recognized on 7C.
Thank you, Mr. Chair. I'd like to preface my quick comment to say that I support the item, Mr. Chair, and I thank you for bringing it. Since I've been elected, and I've been committed to use every tool at my disposal to eliminate the affordable the housing crisis in Miami-Dade County. And then, as we all know, the infill housing program represents an important tool for the county, allowing developers to use, infill housing for rent for affordable rent and for sale. Stating that, we have already stated on record also that there were problems with it, and I think that's why, Mr. Chair, you brought the item. But I don't want I want to make sure that the changes that are needed are not unfairly targeting developers who are doing their best to really bring additional housing stocks to the county. So that's why I bring this amendment because oftentimes the delay is not under the control of the developers, and I don't want them to be negatively impacted for bringing housing and for something that they don't have any control over. So I'd like the attorney to please read the amendment.
You're recognized to read her amendment.
Sure. Commissioner Bastian moves to amend item 7C to clarify that delays that are caused beyond the developer's control and delays caused by extraordinary circumstances include those ministerial delays caused by the county or other governmental entities and lawsuits, excluding lawsuits brought by or against the county that may affect the timely completion of homes to be constructed on county-owned property. Additionally, Commissioner Bastian moves to amend the ordinance to allow the board by a 2/3 vote of its membership to grant one additional extension where the developer has demonstrated that the home is substantially completed. The amendments are reflected in the handout that has been shared with each of the commissioners.
All right, and I'm good with that, Commissioner Bastien. I think that still accomplishes the idea. I mean, it's fair amendment, so I'll accept that amendment. Commissioner Hardiman.
Before I go into an argument regarding the matter, I think that this item is worthy of a continuance, a deferral, just until the next hearing. And the reason why I say so, without getting into any major argument, is because this item affects especially two districts that are not present today, right? So that would be Commissioner McGee's district and also Commissioner Oliver Gilbert's district. Because these items, these infill parcels are primarily located in McGee, Gilbert, my district, and Commissioner, what's your name again? Bastion's district. I've known it for too long, right? Yes, thank you. So I would like, first, before I make the motion, I would like the chairman to be okay with this. And then if not, then we'll make the motion and we'll get into the argument. But I don't want to have to make argument twice about something. This is an issue that, of course, affects all of us in this sense because it's county property, but it's particular to certain districts. And then it elevates discussion about other properties. And so before I get into that, what I'd like to do is make a motion to defer the items to the next hearing so that we can all be here who are primarily affected to discuss it.
Commissioner Hardiman, look, I'm not in opposition of deferring it to the very next meeting. I kind of want to hear your argument just for...
I know, but I think...
I kind of want to hear your argument now.
I don't want to waste all of our time.
Nobody voted against it in committee. It went to committee. It went through the process. I didn't waive it out of committee or anything like that. And yes, you're right. And thank you for saying that. There is certain districts that just have more of these lots, properties, but they are county properties. And I when I brought the item forward, I'll say this. I don't know if to use the term watered it down from my initial thought process to make it as fair as possible to all parties. I really did. And now accepting Commissioner Bastien's as well. The idea is not to create an issue for anyone that's doing. We want more of this. We just don't want someone sitting on a lot for 8 years, 10 years with no movement. Now, if it's stuck because permitting or mitigation of land, that's all covered in this item, protecting them, you could still get extensions based on those issues. It's just when they're just not doing anything. And we have maybe not a lot. It's not the majority, but there's been some of those. I'm just trying to put some limits on that. That's it.
I agree with you that there are issues. You know, I don't think there's anybody who's been most affected by those issues than me and my district. In fact, I'm being sued personally because of those issues between me and my district, which is incredible, but it is the truth. So, you know, my point to you in this is that I'd rather everyone to be included in the discussion so that we can really have the discussion, and then, you know, we decide what we want to do.
I will tell you this. Based on my co-sponsorships and reading the room, I can tell you I can pass it today, but I have no issue deferring it to include the two commissioners that are not present. I understand that. I want to be as inclusive as possible. Just if you have concerns, work with us.
Yeah, I'm here to work with you. I'm not going to hold these.
I will.
But
I will,
I always have great things to bring up in discussion.
I will tell you this, though. I will tell you this. Next meeting is a very, very long one. So if your argument is going to be lengthy, I'd rather you do it now.
Yeah, I don't know if it's lengthy. You never know until you get into the fight, right? So, but no, I mean, I think it'd be good to have all heads included. That's all.
You want to move to defer it?
Yes, sir.
To the next meeting?
Properly moved.
It's been moved to deferred, seconded by Commissioner Bermudez.
Yeah, but I'd like to make a comment first.
Go ahead.
Thank you, Mr. Chair, for bringing up this item, which is important to me. I come from a little bit of a different position, though I also understand Commissioner Hardiman's point of view. And I just want to throw that out there because I was also, with Commissioner Bastien, pulled the item. And I just, and I'm not going to read the language now, though I have some, I like to run it through the attorneys, but I just want to make sure that entities that continue to do this, whether developers or organizations that continue to not meet the standard we've set, they just can't keep on coming back again until they can show us that they have the financial wherewithal to develop these properties for housing. Because in my opinion, I'm going to support the deferral. In my opinion, the infill does impact the whole county, because when we talk about affordable housing, it impacts us all. Every time we talk about the West, we're still talking about the East. I've said this before, and I'll say it again. What's good for the goose is good for the gander. And I think it's very important for everyone to understand that what I find incorrect, and there's no particular organization, so nobody takes this out of context, or no particular developer. If you continue to get these properties and don't do anything with it, there have to be consequences, because we need to put this in the hands of people who move forward and build the housing. And I would like some of that language to be included, and I'm not going to belabor it, but that's what's important to me. Other than that, I'm
All right, so there's a motion to defer 7C, seconded by Commissioner Bermudez. All in favor of the deferral to the next meeting, signify by saying aye. All opposed, nay. And then on that note, if we can pass a similar item, Commissioner Hardiman, I don't think you'll have heartburn over this one. 11A5 does the same thing, but for affordable housing, which is not the infill lots. It's different. So you're good with that one? No, not to defer. No, to pass it, because it's not the same parameters, but not the same program.
But it's
not the same properties in the same districts.
So so my question would be, the parcels for affordable housing, what you're telling me is then that there are a lot more districts that are affected that are trying to build affordable housing than what the mainstay of the affordable housing districts are today.
Well, I know that for example, I don't have infill lots in my district, but I have affordable housing lots. I know that, I don't know how many Lopez has of infill, but I know she has a ton of affordable housing. Same with Regalado. She doesn't have a ton of infill, but she has a gazillion So I don't think it's the same exact, but I just want to make sure you don't have heartburn with that one.
I would ask that it also be included for that reason, for the reason that you have two main districts that, I'll give you an example. Look,
just move to defer it.
Okay, thank you.
All right.
Probably move to defer.
All right, to the next meeting, Commissioner Bermudez moves the deferral, seconds the deferral. All in favor of the deferral signify by saying aye. All opposed, nay. Show that those two items deferred. All right. Madam Attorney,
Your Chair.
who said Mr. Chair? Commissioner Regalado.
Can we take up 8F1?
8F1, let me see. We're on the pool list.
I pulled it to amend it.
We can take up 8F1, yes.
So this item was very properly vetted, and we've been working on it for over 3 years. But at the last minute, we found out that there had been an issue between PIOD and fire. So if the attorneys could read the amendment that deals with this issue, we've spoken with the base and with everybody involved.
Yes. Commissioner Regalado moves to amend item 8F1 to 1, indicate that approximately 2 acres out of the 32 acres of land are currently needed and will continue to be needed and used by Miami-Dade Fire Rescue Department through no later than June 2027 and are therefore declared surplus to the county's needs as of June 2027 following MDFR's relocation. 2, provide that the balance of the 32 acres of land are declared to be surplus as of the effective date of this resolution. 3, authorize the county mayor's designee to retain a surveyor to bifurcate the legal description of the 32 acres as between the acreage to be used by MDFR and the balance of the 32 acres. Authorizes the immediate conveyance of the balance of the 32 acres to the Air Force and authorizes the conveyance of the approximately 2 acres to the Air Force following the relocation of MDFR from that land, which is anticipated to be on or before June 2027, and make conforming changes to the title.
Thank you. And Mr. Chair and the board, it's just fire has a warehouse there, and it's going to take them a few months to get everything out.
All right, it's been moved by Commissioner Regalado.
Move it as amended.
As amended. Commissioner Gonzalez, you're recognized.
I appreciate that amendment. I'd like to include an amendment to add 5 acres for the sheriff's office as well.
Okay.
There hasn't been a request for the sheriff's office, and there's nothing there. They don't have anything there. Did they have?
Yes, I just got off the phone. I just got off the phone with folks within the PBA. Sheriff's office would like 5 acres.
Okay, this is okay. Let me explain something. No one is giving anybody 5 acres. The whole idea here is that this land is going back to the federal government. So, Director Palmer, you want to speak to the request?
Yes,
Chief,
through
you're
the chair,
recognized.
through the chair, Commissioner Gonzalez, the 5 acres you're talking about is the other property adjacent to this property.
Got it.
It's not included.
Not including in this.
It's not
It's the
included
one-
in this conveyance.
It's the one
other
adjacent.
property, and that's the plan.
Got it.
This is simply to give them full access to the runway. This has been the issue with this item, is that the runway is not fully protected. And that's how we started this whole thing like 3.5 years ago. So I'm happy to move it
Okay. All right. So it's been moved.
as amended.
As amended. It's been seconded by Commissioner Bermudez. All in favor signify by saying aye.
Aye.
All opposed. Show that 8F1 and its supplement passed as amended. 8A1 and its supplement. Commissioner from District 12, you're recognized. Yes, on 8A1, the
Yeah,
sole source MDAD.
Yeah, the problem that I see, the words sole source, while they apply sometimes, when I went through the list of some of these sole source, for example, I think it included like grease traps, which I don't think is a sole source, but I'm a little bit reticent, in particular with the airport, to continue to sole source as many things as we do. Some make sense, like, for example, what do you call those tiles on the roof? Whatever, acoustical tiles, that makes perfect sense. But others, don't make much sense to me to be sole source. I just think it opens it up to, not a process where, at least from the public's perspective, is seen as fair and impartial. I kind of felt this way about it when we talked about the procurement process for a couple of months before, or whatever, a year before, on some of the businesses that were getting approved. So that's my concern with this. And while some of them make sense, I would still like to see them, in front of us, because if we don't, then something that may not need to be a sole source all of a sudden becomes a sole source. And like some of the things on the list, I don't know, I'm not necessarily, roll-up door controllers, even video cameras. Competition is at least what I believe will get you, if not the lowest price, the best and lowest price. So that's my concern with this, Mr. Chair, and I'm not. I think we talked about earlier about seeing everything, or seeing most of these things. The grease traps are a tremendous issue for me because, as you know, we have the flow issue, which if we don't resolve that, we're not going to get any restaurants opening up in this county that can grow into big restaurants. So I've got an issue with it. So that's my concern, and I'm going to vote no on it.
Mr. Chair?
Director Kuti, could you approach and speak to some of the concerns that were addressed by Commissioner Bermudez? Thank you.
Thank you, Madam Vice Chair. Commissioner, if I can kind of walk you through the rationale for the item. The purpose of the item is to be able to have us be able to implement certain projects. It's a limited delegated authority, so it's not very far-reaching. It only applies to the 15 projects listed in Exhibit B of the item. So the purpose of it is to allow us to implement those projects faster, more cost-effectively, and with minimal operational disruption. And that's extremely important, and I'll get into that in a second as to why. But it is a limited delegated authority, and it's not for sole sourcing. What it does is it allows the mayor or her designee to specify certain sole source components within those projects. And the reason for that is to allow us to, like I said before, perform the projects more efficiently, faster, more cost effectively, and most importantly, minimize operational disruption. If we have to do tear outs on the airfield, as an example, airfield lighting, there's items in there for doors in the terminal doors, et cetera. A lot of that technology, a lot of that infrastructure is proprietary. So if we have to tear all that out, it creates a significant operational disruption, which results in delays to the projects and also higher costs. So the purpose of this is to just, for those specific projects listed and for those components that are listed, just have that delegated authority so we can specify in competitive solicitations that will go out for these projects, those sole sourced items. That's all this does. So it's not an agreement for sole sourcing per se, although it does mention sole source because that's how the statute refers to it. So secondly, what we did a significant amount of due diligence on the item as required by the state statute. So included in the item as one of the exhibits is approximately 50 letters drafted by about 14 engineers of record that work at the airport in support of this for the reasons that I mentioned. And then as belt and suspenders, we also had our bond engineer who's been at the airport for about 60 years and does the annual facility inspections of all of our facilities and are very familiar with all of our facilities, take a look at the item and also the other engineer of records letters also in support of this. So the idea is not to take authority away from the board, the idea is to have a limited delegated authority just to specify those components in those solicitations. All those competitive solicitations, when they're advertised, will come back to this board for approval. It'll just allow us to just, and for me specifically, minimizing disruption as we continue to maintain our operation and as our operation continues to grow is extremely important. And that's really what's behind the item.
Chair.
Thank you, Madam Vice Chair.
If I could just.
Mr. Chair, may I ask just one other question?
Sure.
I understand, Mr. Director, and I understand your intent, and I think you're well intended. By the way, is that guy that's been there 60 years, was he here when we don't know what's under the airport? I guess he was, right? Because 60 years,
They're a bond engineer.
Oh, okay. Oh, the bond engineer's been 60 years. Oh, okay.
By the way, that was competitively procured a couple of years ago.
Yeah,
Been
well,
around 60 years, but they won it again.
Yeah, well, we still don't know what's under the airport. Only the people that proffered one of the which is amazing to me. But anyways, My concern is what will stop other departments from doing this. And my concern with the sole source process, in particular at the airport, but in other places also, I am not the biggest, well, let me rephrase that. I think our procurement needs a lot of improvement. In our first GET committee meeting, and I think Commissioner Cohen-Higgins was there, and so was Commissioner Regalado, we found out there were 177 ordinances that deal with procurement, which to me is astonishing. But nevertheless, as we seek to be more efficient and more effective, and your explanation is a good one, and I appreciate you and the administration taking the position to try to streamline these things to be more effective and efficient, which is important. I just want to make sure that we just, you know, in being efficient and effective, there are certain things that certainly deserve or could be, like you said, proprietary, and you've been using it at the airport for so long, and they might be that's okay, but my concern is that we don't continue this cycle of business as usual. Right. And I said it to you I said it to you very bluntly, and Mr. Morales after the vote on the concessions, and a group of some others that were in the room. I just don't think it's good policy. I think it sets up really bad. It just sets a bad precedent. Having said that, you've given a good explanation, and I think that you've given me some good response. I wish I would have. It's a good response, but I still feel a little bit of uneasiness. But because I trust in you and believe that you are someone who is committed to making this, bringing this airport into this century, I'm going to go ahead and I feel satisfied with that response, and I'm going to be supportive of it.
Thank you, Mr. Chair. I thank you to my colleague, J.C. Bermudez. I appreciate that. I also wanted to ask, at what point do you all review contracts for the end of the sole source? So when do you reassess to see if there is another company that can provide the services or the materials outside of the sole source?
That's a very good question, Commissioner. Typically, that's an ongoing process. As technology changes, our procurement teams working together with Namada's team are constantly evaluating new technologies. And for example, access control is an area where we've looked at maybe some better technologies, and we may end up bidding that out sometime later in the future. But in the meantime, we don't want to hold up these projects as a result of that. So to your point, it is an ongoing process all the time. We don't wait until the end of a contract. That evaluation is going on constantly between our in-house technical staff, our engineers, and also our procurement staff.
So you're not automatically required to go with that same company if there is someone else available?
Yeah, we always have the option of bidding it out. We weigh the different factors in that. I mean, I'll give you one example. Years ago, I want to say 6-7 years ago, we had a renewal contract for Honeywell because it would have cost 3.5 times as much to tear out all their infrastructure and replace it. But that doesn't mean that we don't constantly evaluate something that maybe could be better than they are or any other system.
Okay. Thank you.
I don't know, Mr. Chair, Madam Chair, hey, just, I want to put a little bit, and I appreciate everything Ralph said, put a little context. This is limited to 4 or 5 major projects that are moving forward at the airport now. D60, we have that brand new multiple terminal, Terminal K, the Central Terminal. And all those projects will be competitively bid out. There are subcomponents in those projects, like the security cards that are used across the airport. I look at Commissioner Cohen, or the lighting on the runway, which is all based on one system. Replacing those in their entirety would be really traumatic, because not only are you going to use different cards in the new terminals, you're now going to have to replace it everywhere else. And so we had the bond engineer look, are there a certain number of contracts that would have that level of disruption that would slow down the project and raise costs? And I think that's what this list is. These projects are going to be bid out overall, but these subcomponents, so that we're consistent with the environment that is the airport. It's really one building, functions as one building, and we want to make sure critical systems, whether it's security, lighting, et cetera, are working hand in hand together and not having different systems.
Commissioner Regalado.
Thank you. I understand the point. My concern is that I don't want us to enter into the zone where if it's a proprietary, then sole source is okay. I find that very concerning because we're constantly talking about, competition and giving people opportunity. But now we're saying, oh, but if it's proprietary, like just have at it. So I just want to know why we didn't consider like pools. Because that's my kind of in between, right? I understand that the RFP process takes a long time. I understand that you may get a higher price because of the time that the RFP process takes. But when we deal with this issue in water and sewer and in solid waste and in a lot of other departments, our answer is to use pools because pools allow us to be competitive, to give different people opportunity without getting bogged down. So is there a reason why we're not doing pools?
Yeah, I mean, to answer your question, Commissioner, the reason we didn't consider pools is because all of these components are project specific to the projects listed here. So all of these projects that are going to be bid out and they have to be designed, et cetera. So the components will all be tailor-made or tailor-designed for that specific project. So a pool wouldn't necessarily be able to address some of the concerns I raised before, which is the disruption, tearing things out, et cetera. So the idea is that it'll be, by having this authority, a limited authority, we can go ahead and include those sole source components for these companies that will design and build these projects. So it's a matter of project specific or versus pools. Pools are great. We use them all the time at the airport, but for more general type things. But for these kind of large, very, very, complex project specific type projects, we wanted to make sure that they were tailored for that. And that's really the reason for it.
I get that. The optics bothers me because, the airport already has its own procurement. So it's already separate, from the rest of the county. And now we're saying, okay, you have your own procurement. You can enter into your procurement process with flexibility that other people don't have. And now we're doubling down on that by giving you more authority for sole source. It's a bridge, right? And my concern is that under the banner of, expediency, we're agreeing to a lot. So that's my concern there. I get it. You want to do it fast, but
Commissioner, if I can make one point. Yeah, we do have our own procurement department at MIA, but we work very closely hand in hand with the county's procurement department and NAMADA's folks. So we handle typically our own construction procurements, but A&Es and goods and services, we work through NAMADA staff. So it's not like we do everything on our own. I just wanted to clarify that. We do work together with NAMADA staff on a lot of procurements.
Through the chair, if I may
recognize
I, Commissioner, thank you. I just want you to know when I was commissioner, I had these very same concerns and worked on procurement issues, of course, at the time. And one of the things that we've done is work through procurement, which, by the way, is not totally separate at the airport. There's a strong coordination with our Chief Procurement Officer, Namada Opal. And so we don't want to be stuck with products that we can't replace, that they're legacy, that's not good for us, and also we want to be sure that other companies can work on the procurement if necessary. So that is part of what we do in the procurement process, to make sure that we're not left with things that give us no flexibility.
I understand, but the state of Florida, the statute already provides the airport with a ton of flexibility. And so this is just like more of that, right? So you already have a lot of flexibility and you bring us items under the banner of we need to get this done yesterday. This is a lot. It's a lot. That's my hesitation is that just the optics of it might not be the best. I understand the purpose of it. It's just the breadth of it and what it's saying about sole source. Every time we have a sole source here, we have to be very explicit in our other departments as to why. And I just feel like this is very blanketed and just covers a lot. That's my concern. Thank you.
Commissioner Steinberg.
Thank you. Okay, so from what I understand with this particular situation here, the county will still competitively bid the construction contracts.
That's correct.
Okay. But you want to maintain them under, or you want to set these pre-existing conditions of what brands and what specific models, because you want there to be some sort of synergy so that there's compatibility between the existing infrastructure.
It gives us the ability to specify certain sole source components within those competitive solicitations.
Okay, but that being said, I have a separate question for you. Are we having issues with the current existing systems that we currently use? Because all we're doing now is enhancing those same systems. So I know it's a $300 million potential savings and cause delays if we go completely different and open it up fully. And I understand that argument. I just want to better understand, are these the best systems that we have? Prospectively looking, if we go forward, are these the brands that are giving us issues already?
Well, again, that's a very good question. It's sort of related to what Commissioner Milan Orbis asked. So we are constantly working with NAMADA's team, evaluating those systems. So anytime that we can find something that's either a better system or better technology, we will always look at pursuing a competitive procurement. That's why even within this, if we have a competitive procurement for some other system that comes in after, we can always bid that out and include it. For example, in D60, we're looking to advertise D60, which is our biggest project in the CIP. It's $1.1 billion. We're going to be advertising that by August. So we're looking at right now our access control system, which is our security system, because we've been told that there may be some better systems out there. So we are working on scoping the actual RFP for that, which will come out sometime later in the fall. But that's going to be after we advertise D60. But we will still have the ability, as D60, it's going to take about a year to get that project awarded, and that's a design build. While the project is being designed, starting in summer of '27, we will still have the ability to fold in that access control system, assuming we decide to change it. So we do have the flexibility to do that.
Okay, I'm not sure you fully answered the question. In terms of the existing infrastructure that we have now that we're trying to tie in,
Mm-hmm.
when we have the flexibility, but then we're saying we don't have the same flexibility because we want to stay with those for the cohesive future. Like, if it's going to save us $300 million now, in the future, if we have issues, it's going to cost us more. So I'm just trying to get there. So help me get there.
Right, okay. So, I mean, the $302 million is a conservative estimate as far as the savings that we would experience. I believe it's going to be significantly more. But that being said, any time that we identify a system that is not working properly, I hope this answers your question, then we do have termination clauses in those contracts where we can eliminate them. I'm not sure if that answers the question. No.
Through the chair, Commissioner, I think what you're asking is, of these like 13 to 15 systems that were identified by the bond engineer as being not necessarily proprietary, but sole sourcing them because as part of the ecosystem of the airport, if you're going to put new ones, you're going to have to rip everything out, that kind of stuff. Your question, I think, is it our opinion that those 13 to 15 actually are good systems?
Yes.
That's what you're saying. Or are any of them problematic? I think that's the question, Ralph.
I'm sorry, the answer to that is yes, and the one example that I use of one that we're looking at maybe replacing is our access control. But yeah, the answer to your question is yes, Commissioner. I'm sorry if I misunderstood.
All right, Commissioner Regalado.
Yeah, just a thought. Ralph, would you be open to the idea of limiting this authority a little bit so that it has to come to the full BCC? Maybe it doesn't go to committee. Maybe it just comes to the full BCC, just so that we can see the numbers and just see it. Like, do we hate that idea?
I'm trying to understand your question. So what you're saying is come back to the BCC for the award?
For the award.
That's going to happen anyway, as a matter of course. For all these projects, they're going to be these components will be specified in these competitive solicitations. So those awards will come back to you. I guess one thing we can do is break out those components within that award to show what the cost was. I don't know if that.
Yeah, but I just feel like we need more information on it. And maybe the problem is when it comes back to us, it's still a sole source, right? So we have to approve it because it's a sole source. But can you provide us with, right, it's an award, right?
Commissioner, quite frankly, I don't know why we need this item. They kind of do this now, right?
Well,
kind of do this now?
Not really. Anytime we have a sole source contract that we're going to procure, it has to come to the board for approval.
Right, so the process for the sole source is different than this. We are giving them authority. I just think we need more information on it because we have no way to vet what the price would be if we didn't go with the sole source. Like there's just a gap there. And I understand why you want to do it, and I get it. I just feel like maybe the answer is to provide the board with more information about what the market, and look, Namita does that. She gives us like a market, kind of perspective. I mean, can you tell us in the item what your feelings are on the sole source price compared to the market? Sure. So that at least we know, at least we can see something, right? And we can up or down, because right now you're just going to come with this and say, this is a sole source, it costs $1 million and there's nothing we can do about it, approve it, yes or no. So can we add the component of a market analysis?
Sure. So I think if I understand your question correctly, Commissioner, when an award for any of these projects come to the board, you want to have a market analysis for those sole source components in that award included in the award item.
Yes. So we can't make it competitive, but at least we have an idea of what the competitive market is when we vote on it.
We can certainly do that.
Okay. I don't know if the maker is okay with that, but that would be my friendly amendment.
This is a depart. Is this who's? Oh, this is your item. Jimmy.
Just quick comment, Commissioner, through the chair, Commissioner, I would ask that we include, though, in that as well, not just the competitive pricing,
the cost.
but what's the cost to the airport of replacing our existing system, because that's part of the
That would
savings
have to be
here.
included.
That's fine. That's
Okay.
fine.
It's not just that. It's what I mentioned before, is the operational disruption and the cost to tear everything else out. That has to be included as well. It's not just the cost of the item. And
Commissioner Cohen-Higgins, is that a friendly amendment?
Sure.
Okay. All right. Show it. Moved by Commissioner Cohen-Higgins as amended, seconded by Commissioner Gonzalez. All in
Mr.
favor of, go ahead.
Chair, no, go
Yes.
ahead, call the vote, sorry.
All in favor signify by saying aye. Aye. All opposed, nay. Show the item passed, and you're recognized.
Mr. Chair, while we're on the airport, if I can have the director approach just for an announcement that I think he and I also believe is rather important. I think it'll take less than 2 minutes. Thank you, Mr. Chair.
You have like 30 seconds.
Okay. Thank you, Madam Vice Chair. So first of all, it's my pleasure to share this information with you. Before I start, I want to thank the mayor and the chief for their leadership, and I want to thank this entire board for your support of our airport. Last week, we received our latest updated economic impact and jobs numbers. We had a significant improvement in those. I mean, as all of you know, we are the state of Florida's #1 economic engine. Our numbers jumped up as far as annual economic impact. We jumped up from $181.4 billion to $212.1 billion. That's a 17% improvement in economic impact. And our jobs impact jumped from 843,000 jobs annually to about 950,000 jobs. So almost 1 billion jobs annually that are direct, indirect, related, and induced to our airport. So great news on that front. That is a direct result and is being driven by the explosive cargo growth that we've seen over the last year. We had a 13.6% increase in cargo year over year from 2024 to 2025. We moved about 3.5 million tons of cargo.
All right, Director. Thank you so much for your time.
Got it.
All right. And that was much lighter than what I was actually going to do. All right, 8G2, Commissioner from District 13. Commissioner from District 13, you're recognized.
Thank you, Mr. Chairman. Yes, and this is an item that we talked about, I think, in the last or previous county commission meeting, when there was a debate in the legislature of removing the ADAP dollars to cover for treatment for HIV, and we have made a motion for some dollars to be appropriated for HIV to cover the nexus.
This is the car one.
Which is this one?
Cars.
Financing vehicles. It's all right. You want to continue on the other one? What were you on, DOH contracts?
Let's go to yeah, let's do that one, Mr. Chairman.
8G3, you're recognized because you're the one pulling bifurcator, pooler, whatnot. Go ahead.
And I appreciate that, so this is what happens when you're doing 10 things at the same time.
We all are.
So I appreciate that, Mr. Chairman, for your indulgence. And yes, this is just a simple item that we're going back and making sure that the $1.1 million that were allocated to the Department of Health, that $300,000 of those dollars will go for HIV testing to try to see if we can mitigate and lower the HIV rates in Miami-Dade County. So I think I have the county attorney that could help me read the amendment.
Okay. Go ahead.
Good afternoon. So Senator Garcia moves to amend item HE3 to revise the following direct local contribution line items while maintaining the same total county contribution of $1.133 million. On page Miami-Dade County 018, amend Attachment 2, Part 2, Section 9 to remove the individual line items for HIV/AIDS local funding, testing for communicable diseases in prison, Comedia, Project STD, Public Health Trust contract, health and environmental services, and AIDS take control with a local contribution of $342,318, and add a new line item for testing and prevention with a contribution of $342,318. Is the motion.
All right, show it moved as amended by Senator Garcia, seconded by Commissioner Lopez. Commissioner Steinberg, you're recognized on the motion. Show Commissioner Steinberg added as a co-sponsor, and Commissioner Lopez and Commissioner Bastien. All right, with that, all in favor of the item signify by saying aye. All opposed, nay. Show 8G3 passed as amended. All right, Senator Garcia on 8G2 now. Okay, so Commissioner, who's the sponsoring commissioner on this? Or department item? All right, Commissioner Gonzalez will move the item, seconded by Commissioner Bastien. All in favor signify by saying aye. All opposed, nay. Show 2 no votes, and the item passed. 8K1, Commissioner from District 6, you're recognized.
Thank you, Mr. Chair. I've talked to the department since I pulled it, and I feel a little bit better. I had hesitations because the system is changing for housing vouchers to a point system, and so the distribution of points, I wish that our board had more input or knowledge of this change, and I told the director that, and I just want to make sure that our elderly applicants are receiving equitable points and access to the housing vouchers. So that was a comment that I just wanted to put on the record, and I would love to continue discussing this with you. As I did want to ask, was this a HUD requirement?
And our director,
If I may,
please answer.
You may.
Yeah, because I wasn't clear on that when I spoke.
Nathan Kogan from the chair, yes. HUD strongly encourages to set preferences through our scoring for Section 8 and for public housing waitlist, yeah.
Okay. Thank you.
You're welcome.
Thank you. That's all. I'm good with it.
Show this moved by Commissioner Orbis,
Yes, I'll move it.
seconded by Commissioner Bastien. All in favor signify by saying aye. All opposed, nay. Show the item pass. Commissioner from District 12 on 8 and 4.
Thank you, Mr. Chair. I'm going to be supportive of it because we got to get it along, but I want to point out to all of you, my colleagues, that this was awarded in December 21st, 2023. 2.5 years later, it's coming for an award with us. And I just think, with all due respect to the administration, that as we ask our staff and the county to be more efficient, it behooves us to make sure that when we need, we should get the information timely. I know it's beyond the 120-day time frame for goods and services. This is important. It deals with, obviously, transportation, critical transportation for our county. But I want to make sure we become eagle-eyed on making sure that things occur timely, so we don't see things 2.5 years later after they've been awarded. So other than that, I'm going to be supportive of it because it has to get done. And it has to be approved. So either way, it's going to put us in as one of my colleagues loves to say, a conundrum. So we want to avoid that. But to the administration, obviously, if we can avoid some of these things in the future,
Yes.
that would be what is important.
All right, sounds good.
If I may, briefly through the chair, just
may.
want you to know that there wasn't a system at the time, and there is now a system, and it will not happen. We hope again.
All right, show it moved by Commissioner Lopez, seconded by Commissioner Gonzalez. All in favor signify by saying aye.
Aye.
All opposed, nay. Show the item passed. All right, Commissioner from District 8, you're recognized on 8 and 6.
Thank you, Mr. Chair. I pulled it because the administration has an amendment. If they'll read the amendment proposed for 8 and 6.
All right, to the administration or the attorneys, you could read the administration's amendment.
Yes, Commissioner Cohen-Higgins moves to amend Agenda Item 8 and 6 to insert in the 15th line of the title of the resolution, after the word funds, and in Section 3, after the word funds, the following language: of up to $24,980,000 upon approval of a subsequent capital budget.
All right, so show it, well, Commissioner from this, well, show it moved as amended by Commissioner Cohen-Higgins, seconded by Commissioner Gonzalez, and then Commissioner from District 6. You're a pooling commissioner as well.
Yes. Thank you, Mr. Chair. So as we are renovating these bus shelters and changing them, are we looking for additional ways to generate revenue from them? For example, it has a lot of paneling. Are we looking at ways to put ads on them? And I don't mean like LED ads. I mean just, basic like paper ads. Are we looking for maybe putting solar panels on them on the top? Are we looking for charging, like different things that we can do with it to generate funds back to us from these shelters?
Thank you, Commissioner. And through the chair, our director, Stacy Miller, will respond.
You're recognized, Director.
Thank you, Stacy Miller, Director and CEO of Department of Transportation and Public Works. Commissioner, in response to your question, these particular shelters do not have advertising associated with them. Of the shelters we already have, approximately 800 are large enough to have advertising associated. These are smaller, they don't have side panels, and therefore don't have marketing associated with them.
But they do have glass in the back.
They have it in the back, but not on the sides. We usually only advertise on the sides, not on the back, for safety.
Okay. Okay, thank you.
Commissioner Regalado.
Thank you. I'd just like to add that we talked about this at committee, and one of the things that I proposed was changing our advertising rules for bus shelters, because there are a series of restrictions that limit our ability to maximize that advertising. So the placement is an FDOT thing, but for the ones that do have advertising, we could eliminate some of the restrictions and help the Department of Transit out. So I hope at some point we consider that. Thank you.
Commissioner Hardiman.
Can we have the director back, please? Thank you. So in my district, we have some particular problems as it pertains to bus shelters. So for instance, we have some historic structures in our community that have been around for a very long time, where they used to function as bus stops and shelters, and then Miami-Dade County stopped maintaining them. And so they fell into disrepair. Many of them are broken. They certainly don't include the lighting anymore. I've been told that they can't find the documentation that even supports how the lighting was properly wired to the electrical systems. We put money from this district into those restoration of those sites, and it's been a very slow process. I mean, this has been taking years for something that should be done relatively quickly, and so we've been asked to make certain considerations. So, for instance, instead of going with the electrical, because it's been taking so long, maybe going with solar powered sites, et cetera. And so we've been agreeable because we want to have the community look better than what it does. Particularly the area that I'm describing is on Martin Luther King Jr. Boulevard